Good morning. I'll call to order this February 4, 2020 Seattle Waterfront LID assessment hearing. My name is Ryan Vansel. I'm the hearing examiner for the City of Seattle, and I'll be presiding at today's proceeding. The City Council formed a local improvement district for the Seattle Central Waterfront Improvement Program and to assess a part of the cost expense to certain of those improvements against properties identified as specially benefiting from improvements. The purpose of this hearing is different from the formation hearing held in spring 2018. This hearing is a quasi-judicial proceeding at which the hearing examiner takes evidence from objectors in the city concerning the special assessment for special properties. This hearing is not to simply provide members of the public with an opportunity to appear and provide their views on the formation of the LID or to ask questions. Instead, objectors are appearing through legal representatives or appearing in their own behalf, essentially as their own attorney, to present evidence and testimony to support their objection. Objections should be directed at the amount of benefit that the property will receive or not from the proposed improvement. Testimony should not be directed at matters concerning the formation of the LID, which has already been completed. Before testifying, each witness or testifier must take an oath of affirmation to tell the truth and will be subject to questioning by opposing parties. Any evidence you want me to consider must be relevant to the issues raised in the objection and come from a reliable source and have some value in proving the point to which the evidence is offered. Again, this is not just an opportunity for public comment. The proceeding that we're going to go through today in part is dictated by who showed up today. One of the things that I'm used to with many of the hearings that I do is I have an opportunity to do a pre-hearing conference to schedule and bring everybody into a timeline. The uniqueness of this hearing, however, is that under the statute, objectors are able to file up their objections up until this moment. And so what the proceeding today will essentially be as a start, as a pre-hearing conference for me to calendar and to bring some order to those individuals who have filed objections and plan on presenting in addition to filing the objection. We have about 400 objections filed. I don't see 400 people here, but many of you may be representing multiple objectors. Some of you did contact our office in advance and have pre-scheduled hearing dates. Some of you will need to work that out today. You are here also in sort of separate categories. We've had indications from many of you that you'd like to speak for 5 to 10 minutes. We will be accommodating those speakers starting today, and we will continue through those speakers until we're finished, possibly through tomorrow, possibly through next Tuesday, depending on how many of you there are. And those will be determined by case number. You have each been given a case number, and those will be called chronologically, starting with case number 1 through case number 400, and that will dictate when you get your chance to speak. Some parties submitted pre-hearing motions. I'll come back to that, but I know that you're all anxious to hear about how the hearing will be proceeding. So again, those objectors who are anticipating 5 to 10 minutes to present your objections will start today. We will be calling 5 case numbers at a time. They will be posted on the whiteboard over here to my left. There are 5 seats reserved for you up front here, that when your case number is called, if you're one of those 5, please come forward and sit in one of the reserved seats. If we don't see anybody in those seats, we assume case numbers 1 through 5 don't have anybody here, and we'll move on to 10 through 15 or what have you. So, because we don't know, again, who is going to show up here today to present oral testimony in addition to the objection they've already filed. And we'll be working through those cases today in chief. For those who are going to need, say, 20 minutes to half an hour or even hour or longer, those will be calendared for specific times for you to come in. And we have dates that are essentially spread out through this entire month to hold this hearing. And many of you have already got some of those dates scheduled, and we'll be working those out with you shortly. I'll come back to the steps for getting our individual objectors who are here for just 5 to 10 minutes. We are going to try to get you started here today so that we can get through this and you don't have to sit through the entire process. But I do need to work out some ruling on some motions that were submitted in advance first, and also see how far we can get in calendaring with these other parties. Can I have a show of hands of how many individuals are here today and are planning on presenting their objection for 5 to 10 minutes? All right, we're going to work through you pretty quickly then. Again, today coming in here, I didn't know if I would have 100 of those people or less than 10 as it appears. And so that does gain us some time on the calendar also that we'd set aside for those individuals, for those who need more time to present, to get a specific time set. Individuals who are planning on presenting for an hour or less, please raise your hand. Okay. And individuals who are representing more parties than that and plan on needing more time, and that's undefined at this time. Okay, several of those. I may try to work out some time with you folks before we get too deep into the hearing, but I do want to issue a ruling on some of the pre-hearing motions before I do that. For pre-hearing motions, the hearing examiner did receive some motions to continue the hearing, and at least on one of those grounds, the hearing examiner has already issued an order. Motions for continuance on the basis of lack of availability of the final special benefit study and the addenda volume. This motion has been denied. These requests for continuance have been denied, and or if they're standing and have not been addressed by the standing order that's been posted. The documents have been available for 1 month. Information is not radically changed from that which was earlier. And the parties in the motions received to date did not specify specific prejudice in their requests. And that's the reason for the denial. I also received at least one request to continue due to a issue raising a State Environmental Policy Act challenge, indicating that there has not been compliance with procedure under the State Environmental Policy Act, or Cepa. No continuance will be granted for that item, as this is an assessment. This hearing is to hear objections on assessments. Whether you've been properly assessed or improperly assessed is the subject of this hearing. There's been no reference to a Cepa appeal that's been filed. I don't have one in my office. There isn't any case number reference to a Superior Court Cepa challenge. This is simply not the forum to challenge Cepa. Similarly, if the assessor got a ticket on the way to assessing your property, I wouldn't hear that issue. The traffic court would. Cepa is a separate issue that doesn't come up in a special assessment hearing. It doesn't mean that you can't challenge that somewhere. It just means that, just like the traffic court, I'm here for a specific reason. You need to address that specific forum in another venue. And I certainly wouldn't be providing a continuance to provide briefing for or challenges on that issue. In addition, there were requests for a discovery to be performed. The request for discovery, well, at least one of them was received last Friday. Parties who are, particularly those who are represented by attorneys, should have been engaged in discovery some time ago. And requesting it 2 days before the hearing is essentially viewed as an opportunity to try and delay the hearing. Your opportunity for discovery, setting up depositions or interrogatories, started as soon as you wanted to start filing those. And at least a month has passed or more has passed since the notice went out. The hearing examiner is not normally involved in discovery. I do not set discovery calendars. I only get involved if there's a dispute on discovery. And so I assume those of you who need discovery, if you're going to be deposing witnesses or sending out interrogatories, that you're doing that on your own time, that you've already taken the initiative to start that. And so barring a failure to respond by a party or something like that that's addressed in a motion to me, there will be no delay for discovery. There was a question about the hearing examiner rules that are applicable to this proceeding. The hearing examiner rules were identified by the hearing examiner, and those rules that are applicable are from the hearing examiner rules of policies and practices, are posted on the Waterfront LID site. If you need that website, if you've not already had access to it, please ask the individuals downstairs for that address, and you can look up the specific rules that I identified from the hearing examiner set of hearing examiner rules that control in this case. If you went to the hearing examiner rules that are generally applicable that we have on our regular website, many of those are simply not applicable here, and I went through all of those to determine which were applicable in this case. This case is one in which I will be making a recommendation to the council. I'm not making a final determination, so there are some appeal rules that simply are not applicable, and in some cases there's so many of you that trying to manage a hearing with some of those rules, they're also not applicable. So if you want to know which ones I've already determined are applicable, you go to that website and you can function under those rules. All right, I think that addresses some of the pre-hearing, at least some of the pre-hearing issues, and we can come back to some of those later. Let's try and do some calendaring if we can get some of you on the calendar. Those of you who have a need for, there was a group of hour or less, I'd like to get you on the calendar first because you're the easiest, essentially. I've got a group of individuals. Where's my legal assistant? Okay. So I've got a group of individuals that are doing 5 to 10 minutes. We're going to get through those today, it appears. And so we have on our calendar dates, times available now that we'd reserved for 5 to 10 minute objectors. Now the 5th and the 11th are open. And so I'd like to populate the 5th and the 11th. And this is just done by order. As you can see with the number of people, we cannot accommodate schedules. So you've stepped into a quasi-judicial hearing, just like a court doesn't check with everybody about when your vacation is and your availability. I try to do that with many of the hearings I hold, but in this case, with the number of people, we simply can't accommodate the niceties of everyone's schedule. So I will give you a time. We're going to give you a time to meet with Mr. Galen Edlin Cho. He is my legal assistant. Those who need an hour or less, please meet him in the lobby now, and he will set you up with times and dates. 5 to 10 minutes, you're already covered. You're going to go as soon as we get through this initial process. I saw about 10 people raise their hand and say they need an hour or less, but more than 5 to 10 minutes. I'm not going to do anything that you're missing, so we just want to get you on the calendar. Mr. Edlin Cho, we're going to take these individuals by case number and put them in order on the dates of the 5th and the 11th. If we carry over, just pocket them in where you can on the dates where we have available. These are hour or less. Once that's done, please return. All right, turning to those individuals, we can get some work done while they're working that out. Individuals who are here and need more time than that, I can try working that out with some of you. So there's no particular order to it. We're going to please come up to the mic here. I saw 3 or 4 of you. And I just need to know your estimated time.
Yeah, Mr. Examiner, I have 2 preliminary questions. We have 29 different clients. They're each going to require about a half day. And the one thing is that apparently when we filed this request for a pre-hearing conference with all the different parcel numbers, they were assigned one case number and they should each have an individual case number. We filed individual notices of appeal, objections yesterday. So I'm just wondering how you would like to handle that. I don't think we need one case for 29 different parcels.
I'm sorry, you just said you don't think you need one case for 29?
We
or
would
you
prefer
want more?
an individual case number for each of the appeals as opposed to one case number for all 29 appeals.
So case numbers were assigned by representative, not by parcel number.
Oh, okay.
This is the case numbers. Essentially, this is a consolidated hearing for 400 parcel numbers that are being heard separately with a variety of representation styles. Maybe one individual representing 29 or one individual who owns 2 or 3 parcels. So there's really no fine way to identify this.
Okay, and that's
it's just our
fine.
internal method of coming up with some organization to the group. So there certainly isn't any prejudice to your case by having a single case number for your clients.
Okay, thank you. And then my other question was on your comments about the Cepa challenge. At least as we're phrasing it, in this proceeding, what we're seeking to raise is an assessment challenge, which is that it is improper to finalize the assessment roll for elements of the waterfront project that have not undergone Cepa review, because once the roll is final, then the council is committed to build it, even if they haven't done Cepa review. And it's our understanding there hasn't been any done on Pier 58 yet. So either you'd need to wait for that, or you'd need to pull that component of the assessment out and do some sort of phased review and have a smaller assessment now and any future assessment for the park if and when it gets approved. And actually, there's a similar challenge for the Pike Pine improvements, not down by the market, but up to the freeway.
And any argument you intend to raise as your part of your objection will be better raised during the period you've been assigned for addressing
that
your
was
objection.
that was my question.
I'm not going to rule on those in advance, though. That was the request, is that there be a continuance of this hearing in order to do pre-hearing briefing on that issue. This hearing has started, and so we're not going to continue it just to do briefing on that issue. There's no reason that issue can't be lumped in with your primary objection.
And that's fine. And we were trying to phrase it not as a continuance, but as a scheduling issue. But I understand your ruling. Thank you.
Okay. And you're at 29, and you believe you need half a day for each one. There's no efficiency you can gain by because I've got other representatives who are at 2 hours each.
There are several ways that this could potentially be scheduled to be more efficient, because some of the appraisal testimony is directed at the Macaulay study in general. Others are property specific. And so depending on how, for example, if everybody wants to question Bob Macaulay, is that going to be he appears and 400 people ask him questions? Or is it going to be he's our witness in our half day and we ask him questions? And so I leave that part, to your discretion to kind of think about how you'd like to manage that, but we have those questions.
So your time included cross-examination or direct of the city witness. Is that calling?
We have probably 5 witnesses, and if we're efficient, it's probably a half day. And then also there are several properties. For example, Harbor Steps is 4 different tax parcels. So that one is probably not 2 days. It's probably something maybe more than a half day, but certainly not 2 days. That's 4 of our 29.
All right, but to answer my question, in your time estimate, did you include time for interviewing a city witness?
Actually, I was A, hoping for a deposition, and B, assuming that you wanted to do one city rebuttal at the end. So my half-day estimate was for our case in chief.
Okay. At this time, we are planning on having the city come after all of the objections, and so that there would be a single time that the city assessor is available. We can't have him showing up 30 to 40 to 50, maybe 100 times.
Understood.
That would not be efficient for my digesting of the record and to hear the arguments that you have, or of an efficient use of time. You will have an opportunity to cross-examine him, though, and once we have a calendar set here for the objections, which is what I want to hear first, then we can set a calendar for when the city's assessor will be crossed.
And I'd have one other kind of supplement to that is, of our clients, 3 of our clients have 3 different groups of appraisers, each of whom has critiqued the Macaulay study in more of a general way. And so I don't know whether it would, but it might be more efficient to have those scheduled to be at the same time, so we only have one of those general objection sessions that pairs with the Macaulay, but we can also proceed to do it in each of the 29 cases.
Okay. Obviously, there's some unique aspects that need to be addressed with your representation and the 29 objectors that you represent and how that'll be managed. I think we've gotten about as far down that road as we can right now. I don't want to take everybody else's time scheduling just your case. So we will do that. But what I'd like to do is get a feel for what else I'm looking at from these other objectors and see how we're doing out there.
All right, thank you.
And please state your name for the record.
Jerry Lutz, Perkins Coie.
Thank you. Others in this category? While they're approaching, the discussion on appraisers reminded me that I did want to disclose. I've seen in a number of these objections that have been filed a statement from appraiser Anthony Gibbons, and I'm just disclosing for the record that I do know Mr. Gibbons personally. I have retained him when I was in private practice. I've also appeared in cases against Mr. Gibbons. So just disclosing that for the record. I don't see that it would impinge on my ability to make a decision, but just so that it's clear for everyone that I understand his him. I know him from the community.
Morning, Molly Terwilliger. I represent 5 different tax IDs, and we seem to have 5 different numbers. If you'd like me to state them for the record, they're case numbers 336, 337. 339, 340, 342, and we are currently anticipating needing about three days to present our objections. And I will note that we intend to use Mr. Gibbons as our expert appraiser, and I believe that Mr. Lutz will be presenting him as well. So it may make sense to coordinate our hearings in terms of timing, just to save everyone the time of having to put Mr. Gibbons on twice.
Okay. All right, that's all what I'll take from you for now. All right, thank you.
Thank you.
Are there representatives that were in the category of needing more than the 1 hour? I saw more than 2 hands go up, so is that it?
My name is Victor Moses. I'm a
Yeah, I'm sorry. Can you state that again and spell
Victor Moses.
Mm-hmm.
I'm a property owner within the Lid District. I'm acting per se. Mm-hmm. My case number is CWF 0375. And I was one of the people who submitted a motion for continuance based on discovery of the information in the appraiser's files. I assumed that information would be available through a public records request. And it is starting to come out now. I think several thousand pages or so were delivered last night. But from your comments, am I then required to depose or to question the appraiser separately to gather this information? Or can I assume that it will come through public records requests?
I can't answer any assumptions that you would about assumptions, and I apologize, but I can't guide you in how you'll do your case. What I can tell you is that the city representatives will be available for questioning after the objectors present their cases. So there's going to be a succinct time. We don't know what date that is yet because we need to get through the objections for when the city appraiser would be available for questioning. There are parties that are requesting to do depositions with the city appraiser before he appears at the hearing. I do not control that process, and so you really would need to work that out on your own.
And my question is simply, can I subpoena the appraiser and can I depose the appraiser?
At this time, there's no need to subpoena the appraiser. Subpoena would secure and ensure that the appraiser would appear at this hearing when he or she is required to. They're going to be here.
May I depose the appraiser?
There's the hearing examiner rules allow for discovery. I do not participate in that. Deposition is part of discovery, and so the parties are on their own to conduct that.
Thank you.
Yes. If there is a complication, if the city balks and says, no, you may not depose, or you don't provide document, or they don't provide documents or something along those lines, or if they think that you're asking questions that are not permitted, either way, if there's a dispute between yourself or any party on discovery, then that's dealt with by motion to the hearing examiner. Otherwise, the parties are on their own to conduct discovery and schedule it.
Thank you.
Thank you. All right. I think we've gotten as far as we can with scheduling. I will come back to our larger parties later. Elena, can you ask Galen where they're at before I let the city go?
We have 5 scheduled and 5 more to schedule.
Okay, that's going to take a bit of time. The hope was that we would start out from hearing from the city, and the intent there was to hear about the Waterfront LID assessment. I wasn't, and I just want to make sure I'd saw an email come through last night about it, more of an opening statement anticipating argument, and that was a last-minute request that I cannot entertain. The original proposal was that there would be somebody from the city just explaining the process and the project, so it would be clear in the record what we're all here for. Argument, as my understanding from the city, is that they were going to save that for a response to what's come up, so we're not going to do argument today. So does the city plan on having still that presentation level to the record? All right. We're going to wait for that so that the individuals in the hallway can hear it. There's no reason, though, that we can't get them scheduled, and I cannot go ahead and hear from objectors that are here today and are planning on getting in 5 to 10 minutes so that we can start hearing from you and your case. We're going to start with that. We'll finish up with them. We're going to hear from the city. So we'll get some progress in our schedule, and then later we'll have to pause again and see where we're at, and I'll need to come back to our longer term objectors in the back, but I'd like to get the record developed now. So those of you who are here for 5 to 10 minutes, there's only 10 of you, and I've got 400 case numbers to go through, so this listing the 5 numbers is not going to work well. I've got to find you in the record. Who's here for 5 to 10 minutes? Okay, I'm just going to ask the first 5 of you to come up to the reserved seating here. If you're faster than the others, that includes you. Make sure you have your case number with you. This process of listing the case numbers that we're at is not going to do us any good. And I believe I've got how many more are there in addition to these individuals who've come up here? Okay, we'll just wait. We'll get to you today in order. Let me start with the first gentleman on my far right, your far left. If you'll approach the mic. Please state your case number. That's the number that's CWF.
CWF 014Y.
All right, and please state your name for the record.
David Starr. I reside at Continental Place on First and Blanchard.
Thank you, Mr. Starr. Please present your objection.
Okay. I guess I have a question.
And I'm sorry, if you have questions about general process or how the
Where is the city council?
The city council will be here next. This process is one where I make a recommendation to the city council, as I stated in my opening.
Well, this is the same thing we went through.
Except that I have to actually make a recommendation based on law.
What?
Sorry, folks, this is not going to be a question and answer session. You have an opportunity to
So there's
present.
no audience.
Yeah,
I got it.
thank you.
Well, having first heard about the LID proposal in the public meetings of spring and summer of 2018, I was quite shocked by the arbitrary assessment and the absence of city council members at those hearings. Okay. Those who wished to object to the LID were allotted 3 minutes to speak to an empty chamber. The message was clear to all present: the city didn't give a damn. By definition, an LID represents a solicitation by property owners to the city to issue tax-free bonds for investors to purchase. That historically are used to complete small projects in city neighborhoods. And the bonds are paid off by property owners who are the beneficiaries of the improvements. Trust me, I've been in the brokerage business for 42 years, and I did underwriting for LIDs, so I know how they work. So obviously you're using some kind of a hybrid that is not known to me. Not in my wildest dreams would I expect an unconstitutional taking of property without a vote of all the citizens of Seattle. The LID is not a local or intended to provide special benefits. The waterfront is a regional, national, and international destination. No special benefits will accrue to those who have been targeted to participate. Construction estimates are not based upon substantially complete construction documents. They're out of date and uncertain. Final assessments will bind future city councils and future budgets to spend hundreds of millions of dollars on projects still early in the design process. Without more design details and a date certain for completing construction, it is pure speculation what benefits, if any, the LID improvement will yield. If the city proponents want to claim special benefits for property within the LID boundaries, then they must also embrace the chaos on the streets outside of our condominiums, and businesses so included. It goes without saying, the city has a homelessness problem. Just days after I wrote this letter and emailed it, we had a shooting, a massive shooting down where I live. The city was ill-equipped to handle, so they brought in state patrol and sheriffs from outlying counties. Because Carmen Best has been disparaged by the council and by the mayor against doing her job, which is to protect the taxpayers of this city. The beggars on the street, vagrants if you wish, consume alcohol, take illegal drugs with impunity, with the city's blessing. As I said, policing is non-existent in my neighborhood. Speeding, traffic accidents, the only police evidence I see are people getting parking tickets. So it's unfortunate the members of the city council aren't here. I'm sure they're all well-educated people, but from my perspective and many of my neighbors' perspective, they haven't got the sense to pound sand down a rat hole. So that's all I have to say. I yield my time.
Thank you, Mr. Starr. Before we go to the next speaker, we've still got some more in the hall that are coming. I do want to touch on a couple of things while you're all still here. Continuance dates. Obviously, we're going to go beyond today to hear some of these arguments. Those hearings for the continuance dates will be in the Office of Hearing Examiner across the street. That is 700 Fifth Avenue, Suite 4000. Those dates will be posted both on our website, and a link will be provided at the Waterfront LID site, so you can keep track of the hearing. And the hearing is intended to be streamed the entire time. So if you want to see other objectors as they present, you can tune in during those times. You should be able to find the dates for those times on our calendar and or on the Waterfront LID site to get to that calendar. Similarly, if you don't want to come down and see the city argument, if you're not necessarily participating but want to see it, that'll be an opportunity to do that, and that date will be posted as well on the calendar. All right, we'll hear from the next objector. Please state your case name and your name.
Good morning. My name is Lisa Ferguson. My number is CWF 0354. My objection today is mainly about the appraisal of the property. I object to this assessment. Firstly, for many reasons that you've already heard, that this public space, which is open to the world, per Marshall Foster, does not provide me with special benefit. Furthermore, the constant state of renovation and construction on the waterfront over the past 6 years, and with 4 more years at a minimum, has been disruptive to the neighborhood. For example, road closures, sidewalk closures, increased noise, access to sidewalks and roads, to name a few, have been nothing but a negative, and we have received no credit has been received for this constant disruption. Today I'm objecting to the method of the assessment by the appraiser. The appraiser has clearly not seen the property. The appraiser values premium units at $600 per square foot and values those units that are not valued at a premium by the marketplace at $650 per foot. I happen to live in a relatively small interior courtyard view, no air conditioning, no fireplace, and it is appraised at the highest value. Furthermore, units in my stack are inconsistently valued. You would think that the higher the unit, it would be appraised at a higher value, and it is simply not. I happen to be appraised at the highest. I'm on the 4th floor. I'm appraised at the 5th floor level. These appraisals seem to be inconsistent and unfair. The appraiser does not consider my stack, as having less value in the marketplace vis-a-vis the premium apartments, those with extensive panorama views, additional parking, fireplaces, additional storage, etc. And back to the appraisal value of $650 a square foot, there was a unit directly below me that just sold, and it went on the marketplace for 565 square feet. I think our appraiser is inconsistent and unrealistic. And that's all I have to say today, and thank you very much.
Ms. Ferguson, do you have documents you'd like to introduce?
Sure.
All right, those will be marked as Exhibit 1 for case number 354.
That's it.
I'll hear from the next objector.
My case number is CWF 0398, and my name is Mary Moreno. And I filed an objection as an individual.
Sorry, I didn't catch your last name. Could you repeat that?
Moreno,
Moreno,
Moreno. So I filed an objection as an individual owner of a condominium within the LID boundary, but as an HOA board member, I'm also filing an objection on behalf of my entire building, which is Waterfront Landings, the same building that Lisa Ferguson is in. Waterfront Landing has a very unique location on the waterfront and within the LID boundary. On Alaska Way, we were the only condominium west of the viaduct before it was removed. For 20 years, we had unobstructed waterfront views, great access to the Pike Place Market and to the waterfront. One of the major projects funded by the LID, the Overlook Walk, actually gives our building significant detriments and loss of value rather than any special benefit. The Overlook Walk, which will become the roof of the new aquarium pavilion, will block our views to the south. It will decrease our accessibility to both the Pike Place Market and to the waterfront in general, and it will increase noise and nuisance factors. Additionally, the Pine and Elliott Street connector road that is fully a part of the Waterfront project and is being built by SDOT, not WashDOT, will have significant negative impact on our building. This new elevated roadway is being built directly in front of and alongside the south portion of our building. This elevated roadway will block views and block access. This will have a negative effect on waterfront landings, and it was not factored in by the assessor in determining the special benefit assigned to our condominium building. As part of the waterfront project, the city has informed me they are going to plant 9 tupelo trees directly in front of our building. These will block views and decrease value. It will not add any special benefit deemed to increase value. We reached out to the city after the preliminary special benefit study was published to request a meeting to discuss the unique location of our building and the detriments that several aspects of the project have on us alone, but we received no response. I have letters attached. We also pointed out the error the appraiser made in describing our neighborhood. He referenced a waterfront trolley that he described as very popular in the summer. That trolley stopped running 13 years ago. This error was not corrected when the final study came out, and neither were the errors in our assessments. It appears that the city is willing to accept a certain degree of error in their study and their assessments, but as an individual paying that, I am not. So I ask the hearing examiner to please correct the errors in the special benefit assessment that is levied on my building, Waterfront Landings condominiums, to look at the circumstances of our unique location and to adjust our assessments to reflect the significant detriments that many aspects of this project have on us alone.
Thank you. And do you have documents to introduce? Those will be marked as Exhibit 1 for case number 398. Thank you. We'll do one more objector before I check in with everybody again. Please state your name and your case number. And for case number, I'm sorry, folks, you don't have to do the CWF, just the last digits at the end is your case number.
My case number is 385. My name is David Jacobs.
Please proceed.
The city has formed a fundamentally flawed waterfront lid in an arbitrary and capricious manner that unfairly abuses residential property owners within the lid's boundaries. The city's appraisers created documentation supporting the city's formation of a fundamentally flawed lid in an arbitrary and capricious manner that also unfairly abuses residential property owners within the lid's boundaries. There is a preponderance of evidence supporting my assertions, though I will only address one key point. An essential part of the lid's legal foundation is that the lid's improvements create special benefits or increases in property values. Another critical part of the lid's legal foundation is the requirement that it creates an excellent park. This is a matter that doesn't seem to get much play in conversation, but I'll attempt to fix that. My comments will address whether the lid will, in fact, create an excellent park and why the creation of an excellent park is critical to the lid's legal foundation. First, let's scan the lid's list of improvements. According to City Ordinance 31-812, intention to form waterfront lid, Exhibit C, a description of waterfront lid's improvements covers 6 projects: the promenade, the Overlook Walk, Pioneer Square street improvements, Union Street pedestrian connection, Pike and Pine streetscape improvements, and additions to Waterfront Park. The problem with this list of improvements that we're being asked to pay for is that it doesn't create a park. The top 10 words from the 215 words in Exhibit C were counted by a word counting program that I used. The top 10 words are street, pedestrian, avenue, Pike, waterfront, improvements, way, pine, Alaskan, elevated. Those words total 55 counts out of 215 words, or 26% of the LID's descriptions. Street and sidewalk related words totaled 42, or 20% of the 215 word total. While the LID is a highly legal creation, we do not need to suspend common sense, which makes it clear that the Alaskan Way corridor cannot be transformed into an excellent park. An excellent park simply cannot be created within a roughly 200-foot wide city right-of-way, bounded by significant urban development on the east and huge warehouses, creating mostly peekaboo views of the water on the west, bisected by a 6 to 8 lane divided major truck street, as Alaskan Way is formally designated. A walk from the ferry terminal to just north of the aquarium, stopping at Pier 6263, covers the heart of the LID's expenditures for street and sidewalk improvements. No reasonable person would expect an excellent park to emerge from within the physical constraints of this roadway corridor. Conveniently, by walking a short distance north of the central waterfront, Myrtle Edwards Park, excluding its close proximity to active railroad traffic, provides a vivid contrast between it and whatever the Alaskan Way is or could be, making it crystal clear what a park is and what a park is not. For better or worse, the LID's fundamental nature will remain the same. At its core, it's a major land and water transportation hub, and as such is a noisy, congested, and touristy part of town, not frequented by people who actually live there. From a common sense standpoint, it's pretty obvious LID improvements cannot create an excellent park. Let's consider the assertions. Let's follow up the previous by considering the assertions by both the mayor and the city's appraisers that the LID's improvements will create an excellent park. Mayor Durkin asserts the new waterfront will attract locals and tourists from around the world, rivaling Vancouver's Stanley Park. Seattle Times, January 3, 2019. Comparing the waterfront strip of city right-of-way, covering 36 acres and averaging about 200 feet in width, to the truly spectacular Stanley Park at nearly 1,000 acres in size, almost twice the size of Seattle's large Discovery Park, strongly suggests the mayor has never walked through Stanley Park. A park so massive you could spend a week exploring it and never come across its 1,200-yard par 54 pitch and putt golf course. Valbridge Partners, the appraisal firm used by the city to create the waterfront special benefit / proportionate assessment study for the lid asserts, with the project elements completed, AKA the lid's 6 improvement projects, the area will be upgraded to an excellent park, which indicates average 5% increases in condominium values situated within 3 blocks of the improvements / new amenities. The city's summary of final special benefits proportionate assessment study was created in a fundamentally wrong, blatantly misleading, arbitrary, and capricious manner. For example, it falsely asserts that the central waterfront would be considered a park, according to the park grading scale in John L. Crompton's landmark research on the economics of parklands, which appraisers heavily manipulated to manufacture special benefits for lid properties. The appraisers falsely asserted that the central waterfront would be an average park on Crompton's grading scale. It falsely asserts the lid's list of 6 improvements would elevate the central waterfront to an excellent park on Crompton's grading scale. It used these falsehoods to manufacture special benefits by ignoring the fact that Crompton's work and his grading scale was based upon real parks, such as of the quality of Seattle's Washington Park Arboretum, Seward Park, and Green Lake as good examples. Ironically, Crompton's landmark research, documented in his paper entitled The Proximate Principle, was written to document the value of park development to property tax bases of local governments in a manner completely opposite to the way the city and its appraisers have used it. In essence, Crompton documented that both the land acquisition and the cost of improvements for new parks could be entirely financed through increases in the city's bonding capacity created by the increased property tax receipts generated by the increases in property appreciation, aka special benefits, experienced by properties located in close proximity to the parks. No lid required. After appraisers labeled the lid improved waterfront as an excellent park, they corruptly manipulated Crompton's system to manufacture increased property valuations based upon proximity to the newly labeled excellent park, creating from thin air the lid's special benefits, the foundation necessary for it to be legal. Pretty darn slick. This magical process plays out on pages 44 through 47 of the assessment study. While marketing puffery is something we are all aware of, in the case of the waterfront lid, it is something of very important consequence, since the appraisers have misused park status to create this assessment study's special benefits. When used properly, lids are very useful tools for financing infrastructure desired by property owners for which a city has little interest or capacity to fund. In closing, let me be clear, for better or worse, the waterfront's fundamental nature, past, present, and future, will remain the same. At its core, it's a major land and water transportation hub, and as such, it is noisy, congested, touristy, and a place most nearby residents don't frequent. Thank you for the opportunity.
Thank you, Mr. Jenkins. Did you have documents you want to introduce, like your statement?
I emailed my objection.
Okay,
And it has all of this and lots more.
excellent. Thank you. We'll take a pause from hearing from objectors. I saw maybe 7 to 6 more that we will get through today. We also have, I want to come back to Mr. Lutz and Ms. Terwilliger. Before that, though, while I have you all here, I want to take advantage of the fact that you're here and give you an opportunity to hear the overview from the city. We're going to do that. Then we'll return to the individual short objectors that we've started with this morning. And then I'll come back to Mr. Lutz and Ms. Terwilliger after we've heard from those objectors and try to get you a calendar. In part, I'm waiting because depending on how many objectors we get through today, we free up time on our calendar that we've already got. City? Before the city starts, I will note, if you have a date and time, you don't have to stay at this point. You're welcome to stay to observe the hearing. You can observe it by streaming. That's at your election. But once you've presented your objection, there's no requirement to stay in the hearing room. City, please.
Thank you, Mr. Vansel. My name is Mark Filippini. I'm with K&L Gates. I'm counsel for the city in this case. Also here with my colleague, Gabrielle Thompson, and Engel Lee from the city attorney's office. I'd like to talk briefly about the Waterfront LID, which I'll also refer to as the Waterfront LID. How we got to where we're at today, what folks, at least from the city's viewpoint, can expect from this process, and then I'll reserve, as you said, Mr. Hearing Examiner, any comments on legal standard or issues until later, and we'll close with your leave on some scheduling and process issues, or also I could come back to those later as well. So on January 28th, 2019, the city passed Ordinance 125760 and formed the Waterfront Local Improvement District number 6751. And as I said, I'll refer to that today as the LID or the LID, depending on how I get going. Today we're here to begin the next big step in the Waterfront LID, finalization of the proposed assessment roll under Chapter 35.44 of the Revised Code of Washington. The Waterfront LID is part of the city's $724 million multi-year investment to transform and rebuild Seattle's central waterfront after the removal of the Alaskan Way Viaduct. Known as the Waterfront Seattle Program, this ambitious effort began in 2009 and is projected to be complete in 2024. The project includes new waterfront features partially funded by the Waterfront LID. These include a park promenade along the water, a new surface street along Alaskan Way, a rebuild of Pier 58, which is known today as Waterfront Park, Overlook Walk, that's going to be an elevated connection from Pike Place Market down to the waterfront, and improved east-west connections between downtown and Elliott Bay. Local improvement districts, or LIDs, they're funding tools authorized by the Washington Constitution and state law, by which property owners paid to help fund the cost of public improvements that specially benefit their property. Because certain properties will be specially benefited by the improvements I mentioned, the city included a waterfront LID concept in its Waterfront Seattle Strategic Plan, which the City Council unanimously endorsed in 2012. Efforts to develop the Waterfront LID before us today began in earnest in August 2016, and the LID has been carefully vetted and analyzed since then. I am prepared to talk about how we got to and through formation, but if in expediency, if you'd like me to go through that, I can come right to today's hearing.
My guess is that most of those in attendance are familiar with the formation, so if we can move forward with that.
Okay. As I mentioned, the LID was formed via an 8-0 City Council vote on January 28th, 2019. After the LID has been formed, the final assessment roll process begins also under RCW 35.44. The municipality must prepare a proposed final assessment roll, and once the roll is filed with the city clerk, the city must set a date for a hearing of for property owners to object to their proposed final assessments. Notice letters must be mailed to all affected property owners at least 15 days in advance of the hearing. And if property owners do not file objections prior to or at the hearing, they have waived their right to object. So in this case, on November 8th, 2019, the Seattle Department of Transportation filed the proposed final assessment roll with the city clerk. On November 18th, 2019, the City Council passed Resolution 31915, which set today, February 4th, 2020, as the date for the final assessment roll hearing to commence, and directed the city clerk to mail notice letters to all affected property owners. The city clerk timely did so. At this hearing, property owners may object to their proposed assessments before the hearing examiner. The hearing examiner may recommend that the proposed assessment roll be corrected, revised, raised, lowered, changed, or modified. Further, the hearing examiner may recommend that the council set aside the roll in order the assessment to be made de novo. After this hearing, the hearing examiner will file written findings, recommendations, and decisions with the city clerk for review by the city council. Any property owner who timely objected before the hearing examiner is entitled to appeal the hearing examiner's recommendation to the city council. After hearing and deciding all such appeals, the city council will confirm the final assessment roll by ordinance. Next, I'd like to briefly describe what the waterfront lid entails in terms of the improvements that I mentioned in the funding for same. The waterfront lid will partially fund the construction of the following 6 waterfront improvements that I mentioned earlier, each of which are statutorily authorized local improvements under RCW 3543040 as parks and/or street improvements. Those improvements are the Promenade, Overlook Walk, Pioneer Square Street improvements, Union Street pedestrian connection, Pike Pine streetscape improvements, and Waterfront Park or Pier 58. The waterfront lid area includes portions of Belltown, Downtown, and Pioneer Square, including T-Mobile Park and CenturyLink Field. The boundaries of the waterfront lid were recommended by the city's independent assessor, Bob McCauley of ABS Valuation. The total estimated special benefit to the 6,238 assessable properties within the waterfront lid is $447,908,000. The total cost of the waterfront lid, and this includes the improvements and the estimated costs of creating and administering the lid, as well as financing costs. The total cost is approximately $346.57 million. As a result of a protest waiver agreement approved by the City Council, also in early 2019 via ordinance number 125762, the actual cost assessed against the properties with the waterfront lid will not exceed $160 million plus the financing costs. And with the financing costs added, the total amount to be collected via the waterfront lid is approximately $175 million. So you can see the monies collected via the lid are funding only a portion of the cost of the improvements at issue, $346.57 million in approximate costs versus a maximum of $175 million collected. City, state, and philanthropic funds will cover the remaining costs of the waterfront lid improvements. Since the city passed Resolution 125760, forming the lid, it has been hard at work in preparation of finalizing the waterfront lid assessment roll. As I mentioned, on November 8th, 2019, SDOT filed the proposed final assessment roll with the city clerk. On November 18th, 2019, City Council passed Resolution 31915, which set today, February 4th, as the date for their final assessment roll hearing to commence, and directed the city clerk to mail the notice letters to all the affected property owners. On December 3rd, 2019, the city sent an email to roughly 1,500 participants on the waterfront lid listserv regarding the February 4th, today's hearing, and including links to the final special benefit study and the proposed final assessment roll. On December 30th, 2019, the city mailed letters to all affected property owners, notifying them of their proposed final assessment and informing them of their right to object and participate in the hearing today. And finally, on January 7th, 2020, the city clerk provided a link on its website to the proposed final special benefit study authored by the city's appraiser, as well as its addenda. As I said, I'll reserve for later my comments on the legal standard to be applied to the hearing. I do have just a few scheduling and process issues to address. If you like, I can go through them now, or I could come back to them later.
I think it'd be helpful to address those now.
Okay, thank you. I understood from your earlier remarks, Mr. Hearing Examiner, that the city will go after the objectors have had a chance to present their cases. In the interest of expediency, we anticipate calling one or more witnesses from ABS Valuation to explain their assignment methodology and conclusions. In other words, to take them through direct testimony. I think that could expedite the process for everyone. Following this direct examination of these and any other witnesses the city calls, the city witnesses, of course, would be available for questioning by those objectors wishing to cross-examine them. For scheduling purposes, the city's primary witness, that's Robert McCauley or Bob McCauley of ABS Valuation, he will be out of the country the week of February 17th through the 21st, but from what I've heard today, it sounds like we will likely be still going through the objectors' cases at that point. The city also understands that several objectors, Mr. Moses raised this issue, have requested access to additional data files maintained by the city's independent appraiser. That's ABS Valuation. Those files break down into two categories: supporting information for final condominium assessments and supporting information for final commercial assessments. We do not agree that the access to these files is necessary for an objector to obtain an independent appraisal. Nevertheless, we're producing them out of an abundance of caution and transparency. The condo files will be made available to objectors on the city clerk's website as of tomorrow. There'll be a link available on the city clerk website that will be live. With respect to the commercial property files, some of those will also be posted to the city clerk's website tomorrow. But other files contain proprietary information of ABS valuation, as well as at least one third party whose information was obtained via a confidentiality agreement. A city believes that at least some of these files are subject to a proprietary materials exemption from disclosure under the Washington Public Records Act. But again, nevertheless, the city is not opposed to providing commercial property files to objectors who demonstrate to the hearing examiner on a case-by-case basis a need for review by their own appraiser or similar expert witness who they intend to call. But we would like to work out some arrangement whereby the party receiving the materials agrees to use them only for this proceeding, to maintain the confidentiality of those materials, and to destroy them upon the final resolution of their objection here or afterwards. Assuming that some subset of objectors will request and obtain some portion of these additional data files, we're not opposed to allowing those objectors to be scheduled at a later date to ensure adequate time to make their objections. But I assume that we will come back to that later today. Thank you.
Yes, there was at least one objector, I think it was case number 97, who had indicated they had requested specific documents from the city, and they had been given a date of February 7th, there would be a response. For objectors who, other than the primary document that I identified in the motion for continuance that was already dismissed, for those that are looking for specific documents, they have them named, they've made a request, and they've been given a date that's obviously either beginning of or into the hearing. Those items, generally what I would expect is that those objectors would be provided either an opportunity to proceed and present their objection, but to keep the record open for them to submit additional argument to match the receipt of documents they've requested from the city.
Okay.
If they're not getting documents from the city, they need an opportunity to use those documents. That isn't a general invitation for everyone to reopen their objection, though. There are specific objectors who identified that, and for those who have identified it, we will work to make sure that their specific request is addressed. Some of this may also be dealt with by either motion or stipulated motion with regard to discovery. You mentioned that there may be a question about whether documents may need to be destroyed or something along those lines. Just a reminder to the city and anybody else that you've got a lot of private information coming in. This is a public record. There's nothing private once you submit it to me. And so you need to make sure that anything you have that comes into the record is redacted with private information, social security numbers, et cetera. Income level, those are things you can black out, or maybe if you want to make testimony to them, they'll still be in the transcript. And so just be careful when you're considering what comes into this record. I have had parties request to have items destroyed once a hearing is over, but that's not something we can comply with because of the Public Records Act. Essentially, once it comes in, it's part of the record. And so what we ask are parties to identify those things and work that out before it crosses the dais, because once it's over here, it's become part of the public record and subject to the Public Records Act. So if council have a different proposal or something along those lines, they may do that through motion, but I just want to let you know our general practice.
Our intent would be to try to work it out privately with the objectors that request the documents. If not, we can bring it to you or pursue a court order under the Public Records Act exemption.
Okay.
Thank you.
Thank you, counsel. All right, we still have then 6 or 7 objectors who indicated they had shorter objections. I want to turn to those next. And then following that, we'll probably take a short break just so I can work out some calendar items and have an educated discussion with Mr. Lutz and Ms. Terwilliger. But I do, because individuals are here, they have a shorter presentations, want to see how far we can get done with those. Those who are here for shorter objections, please raise your hands again. If I could take from this side, those 3, this gentleman here and this woman in the back, please come forward and take a seat. We'll get through the rest of you. Everybody's going to get heard. I reasonably likely will be here before noon, or be out of here before noon for this category of objectors, really depending on the timing of the presentations. As you can see, this is a different hearing than the formation hearing. I'm not truncating time. I'm also viewing this with a different standard. In that case, I was reporting on what you told me to the council to simply tell them what happened. In this case, I am reviewing it under an evidentiary standard and making a recommendation. And so it's a very different hearing if you think that you're here for the same thing. The first individual, please. Please state your case number.
17.
And your name.
Cornelia Dude.
And can you spell your last name for me?
D-U-D-E. I have additional materials to hand up, a 3-page text summary of my presentation today, 7 pages of attachments that illustrate my evidence.
Thank you. That'll be marked as Exhibit 1 for case number 17.
I own condominium unit 345 in Waterfront Landings. You've heard from others of us this morning. This is parcel number 919-587-1870, which is subject to the special assessment. I appear on my own behalf, not as the delegate of any other homeowner. That being said, however, if relief that I seek were to be granted to me, fairness would dictate that it be accorded all other homeowners in the parcel.
And Ms. Dude, just please make sure you speak into the microphone. I want to make sure that you're being picked up, both for the record and for those in the audience who are listening. It might be your scarf that's coming between the microphone and your mouth.
Pardon me? Okay, but I'm looking down here, so that's why I had positioned it down here. My objection to Waterfront LID number 6751 was filed with the Seattle City Clerk on January 8, 2020, and it is incorporated by reference. By its resolution 31915, the City of Seattle delegated to the hearing examiner the City Council's own undertaking to sit as a board of equalization in considering the LID assessment role, endowed with the power, as the city has observed, to correct, revise, raise, lower, change, or modify the role and order the assessment to be made de novo.
I'm sorry, Ms. Dude, but the microphone is just not picking you up, so you'll just need to have it about as far away from your face as this microphone is to me. Yes, there we go. That might work.
The County Boards of Equalization Manual for Washington State states that the legal standard of proof that taxpayers must show in order to overcome the assessor's presumption of correctness is proof that is clear, cogent, and convincing. Equalization will be served by accepting the subject parcel from the residential property assessment roll based on the following evidence, some of which you've already heard about today, but I think my list is even more complete. The roll is based on the presumed homogeneity of all residential parcels identified to the LID. But Waterfront Landings is uniquely different from other residential parcels in that for the past 6 years, the 4 sides of the parcel have been unrelievably surrounded by demolition and construction. That's illustrated by attachments 1 to 4, photographs that I've taken of the 4 sides of our building. I could have taken an additional photograph this morning to update our situation to show you the mountain of gravel that has been dumped on the south side of our building to facilitate the construction of the roads. In effect, we've had a perfect storm of demolition and construction, and it began in 2013. To the west and south, we have endured demolition and construction of the new Elliott Bay seawall, the salmon migration corridor, the western walkway to provide light to the migration corridor, Pier 62, the raising of improvements, soil detoxification, relocation and replacement of water mains and utility conduits, and viaduct demolition. To the east and north, we have more viaduct demolition. We have preparation for the construction of the new extended Elliott Way, preparation for construction of the new connector roadway, diverting traffic from Alaskan Way up to the new Elliott Way, and repeated interruptions of ADA access to Belltown due to viaduct demolition. And I'm sure everyone in this room has visited the Seattle waterfront. The waterfront is here, Belltown is here. ADA access is quite important. Moreover, for years into the foreseeable future, our parcel will endure construction of the newly extended Elliott Way Road, the new connector road linking Alaskan Way to Elliott Way, and as has been observed by others from waterfront landings, by virtue of this road, a number of units will then be below grade and suffer other detriments to their quiet enjoyment. The aquarium's ocean and continuing of the construction and demolition, the construction and demolition that continue into the foreseeable future. The aquarium's ocean pavilion adjacent to the south side of the connector roadway. This was published in the Seattle Times on 12/9/2019. The Pike Place Market Overlook Walk and the Pike Place Market Promenade to the waterfront. The gamut of detriments includes the environmental pollution common to demolition and construction, such as dust, noise, and air pollution, together with air pollution associated with traffic congestion and idling vehicles. Abatement of ADA access accommodation. My attachment 5 illustrates this. It is an email from Waterfront Seattle projecting the 2 to 3 year closure of the Lenora Street elevator and sky bridge to Belltown. Interference with the right to rent or dispose of property. See my attachment number 6, which is a photograph of Zillow's price history for my unit, showing that it has decreased substantially in recent years, and that generally speaking, it lags behind the rest of residential properties in Seattle. Even beyond 2023, when funding becomes available, demolition and rebuilding of Pier 63 will be undertaken west of our parcel, revisiting the Pier 62 detriments, including detours, the noise of pile driving, concrete sawing. This is illustrated by my attachment 7, which is an email from Waterfront Seattle explaining the Pier 63 situation. Surely, no other residential property on the parcel on the roll has been subject to waterfront landings' number, degree, and duration of detriments. Effectively, we've been subjected to multiple simultaneous municipal projects or multiple governmental or community entities. In bearing this burden, we have made our contribution to waterfront renewal. Whether denominated inverse condemnation or any other legal term of art, a criterion that can tip the balance in such cases is the length of time the complainant has suffered the detriments. Surely a continuous exposure to our detriments for what reasonably can be foreseen to span a decade places our parcel outside the cache of residential properties presumed to be homogeneous. Any special benefit that might be derived in the long term is offset by our present special inverse condemnation detriments. I was 65 years old when demolition began in 2013. When the Ocean Pavilion is completed in 2023, I will be 75, with work on Pier 63 still presumably to come. Quiet enjoyment of my home is of great value to me in these years. I ask that the city recognize that value and accordingly grant remission of its special benefit assessment against my uniquely situated residential parcel in order that the burdens on my quiet enjoyment not be compounded by this financial imposition. Thank you.
Thank you, Ms. Dude. Please wait just a moment. I need to do something procedural I didn't do earlier. Everyone who has testified and or will testify in this 5 to 10 minute period, please raise your right hand. Do you swear, Mr. Starr, you too? Do you swear or affirm the testimony you have provided or will provide will be the truth or has been the truth?
I so swear.
Speaking for all of you, thank you. Thank you, Mr. Next.
Okay, can you hear me through this one?
Yes, please
Great.
state your case name, or case number,
Case
and
number
your name.
is 346. My name is Andrea Roy. I am representing the owners of West Edge Tower. We are not here to dispute the benefit of the lid or the methodology behind it, but rather the specific assessment to our subject property. The lid valuation goes to great lengths to establish that the assessments are both reasonable and proportionately established across the lid benefit. This means that for all buildings with the similar highest and best use, those valuations should move proportionately. The lid valuation is assessed as the benefit received by these units based on the base valuation of the represented properties. In the case of West Edge, we have been valued far in excess of any other property in our cohort, in our market, or in our zoning code. In fact, the building itself has been valued at 17% above the highest valuation in that cohort and 33% above other properties. We're asking for this valuation to be reexamined and brought in line pursuant to the methods established by the ABS valuation. Additionally, we would like to have the ABS valuation assessment role amended to fix the errors within it, specifically establishing West Edge highest and best use as commercial, not multifamily. Should the valuation be commercial, we would like to point out that the valuation has been established at a price of approximately $2,400 a square feet. The highest office sale in the city was recently established in November of this year. That is after the benefit study was published at about $1,000 a foot, so more than twice what we've been assessed at. We're not looking to argue, the process or procedure. We're merely asking for a reasonable and proportionate benefit be assigned to this property. We provided additional benefit documentation that was put through last night. We're happy to re-answer that today as well.
Thank you, Ms. Roy. Let's enter that as Exhibit 1 for case number 346. Ms. Roy, I wasn't clear on your testimony whether you were indicating that you believe that the evaluation should be based on commercial or multifamily.
We believe that it should be on multifamily. However, given the outsized impact that a multifamily valuation had, should you choose to value us a commercial, we'll gladly accept that.
All right. Thank you. Next. Please state your case number and your name.
Good morning. My case number is 392, and my name is Kimberly Evanson on behalf of the Pike Place Market Preservation and Development Authority, or the PDA. We're here with respect to two parcels today. Parcel number 800-855-000, that's the Storehouse condominium, and parcel number 197-7200-385, which is known in the assessment role as the North Arcade. Our objections today are only in the nature of corrections of factual errors in the assessments of these two properties. The market does not otherwise object to the lid. With respect to the Storehouse condominium, it's located in the Pike Place Market Historic District, which is subject to multiple unique regulatory overlays that do not affect similarly situated private property. The Storehouse has 3 units. 2 of them, consistent with the market's mission, provide low-income housing. One via Section 8 units through the HUD program, the other through single-room occupancy units. These are units with shared bathrooms down the hall. The benefit is overstated with respect to Storehouse in particular due to 2 principal errors. The first is that Storehouse, unlike other condominium properties in the area, has been separately assessed for the value of its land. And that land is taken and valued apart from the 3 condo units themselves. Now, as we explained in our written objection, which I won't go through in detail, but this matters because that has the effect of overstating the benefit by not applying the land value to 2 of the units which should have been credited for low-income housing. Now, that's the second error, which is compounded by the separate assessment on the land. Now, low-income housing, which is subject to money restrictions and its rent schedule, does not specially benefit like other private commercial properties may. So to correct these errors, a series of calculations would be necessary, which is to reallocate the value of the land that was separately assessed to the 3 condo units within Stewart House, and then to apply the credit to Unit 2 and 3, which both provide low-income housing, as I stated, via Section 8 in Unit 2 and via the single-room occupancy units in Unit 3. Now, the SRO units, they're in the same building as the Section 8. There's no separation. They have separate parcel numbers, basically due to the fact that they had different tax credit schemes applicable to them through the historic district over time. So those units, even though they're not formally income restricted, are functionally income restricted, both due to the restrictions on the market and the amenities that are provided through those units, which are intended to and do serve low-wage workers. So allocating the value for Stewart House and crediting out the low-income housing will result in reducing the special benefit assessed to Stewart House and correcting the errors to result in a more proportionate assessment. The second property is the North Arcade. That also has 2 errors. The first is the building size listed is incorrect by about 10,000 feet. The price per square foot of the pre-lid value is also several orders of magnitude higher than comparable market properties, including market rate properties. As we stated in our materials, the size of the building that occupies the North Arcade, which is part of the covered stalls at the market, it takes up the size of the parcel itself. So the building size actually should be expanded to approximately 13,000 feet. And then a comparable price per square foot should be applied. We suggested, based on contiguous market property, including the main arcade of the market, that price per square foot should be roughly $550 per square foot. And then a corresponding benefit value of 2% would also bring the North Arcade more into step with contiguous market properties. Currently, the 2.9% benefit value is much higher than other contiguous market properties, including the main arcade of the market. So again, the market would respectfully request that these 2 factual errors with respect to each of these 2 properties be corrected and the assessment reflected. Thank you.
Ms. Evans, you made reference to your objection. Did you, in the objection, lay out essentially, did you do the math? Did you do the valuation in that?
We did do the math.
Okay, all right.
Thank you.
Yeah, that's important. People don't just ask me to do it for you. Your argument is your argument. So if it's in that objection, then I understand that you've presented evidence to support the oral testimony you've provided today. Do you have anything to introduce today?
This is just another copy of our objection. I don't know if it needs to be resubmitted.
No, we've got that covered. All right.
Thank you very much.
Next.
So my case number is 355. My name is John Jenkins. And the property address 2033 2nd Avenue, apartment 1112 in the Cristalla building. In my objection that I had 7 points in the objection that I filed, ranging from the constitutionality of the lid to the fact that we don't feel that we have any special benefit coming out of all this. But what I'd like to just go over is the first objection that I had was the market value without the LID, the values that are within the Waterfront of Seattle final special benefit study. I went and looked up similar units in terms of the square footage and 1 bedroom, number of baths and all that, that had sold over the last 6-8 months, compared them to the values that are in the LID, and found them wide-ranging from, there were a couple that were actually under the selling price by up to $100,000, but the vast majority, about 80% of the ones that I looked up, I just did a spot check, I didn't do all of them, ranged from $20,000 overvalued to over $500,000 overvalued from what the actual selling price was within the last 6 months. And I also did with those same units, I did what its estimate, just went to Zillow, got the estimate of it, and they were actually much more in line with what the selling price was although they still were over from $10,000 to $25,000 or something like that. So I went and did comparables to our unit, square footage, number of bedrooms, baths, and found that our unit should be roughly about $700,000. It's valued in the lid estimate at being about $745,000. And so I think our value is, or the value that the LID is based upon is overvalued in the LID market value without LID. And so I'd like an adjustment at the very least for that. And I have the spreadsheet on the ones that sold versus the LID values and the estimates, but and comparables. It's all in what I submitted yesterday.
You've already, those are attachments to your objection?
Yeah.
All right.
So you don't need that, I guess.
No. Thank you, Mr. Chair.
Thanks.
Next.
Good morning. This is case number 137. My name is Shirley Beresford, and I'm speaking today on behalf of my husband and I, who own one of the condos within the lid assessment. We sent our objection in writing and by email, and today I just want to underscore one or two individual points which we wanted to make for the benefit of everybody here. So we're contending that it's pure speculation what benefit, either general or specific, if any, that the LID improvements will create. And that point has been made by several speakers already this morning. But to just point out that the special benefit associated with an amenity such as a publicly owned park is not obviously beneficial, so it's harder to prove, as in the same fashion as a utility extension, which was the original rationale behind the lid improvements. Our property is not receiving any special benefits, and in that case, it's unlawful to include any property that will not receive special benefits, and it's an unconstitutional taking of private property. It's our contention that the supposed benefits are speculative at best. Our property does not have a view of the area of the new park. There will be no view benefit as a result of the waterfront LID improvements. Nearby conditions are currently mixed with heavy foot traffic around the area, made up of residents walking or catching buses, tourists taking advantage of nearby attractions, for example, the Pike Place Market itself, and individuals without a home struggling to find a place to rest and stay warm, or to obtain additional funds to support them. The density of this mixed foot traffic and its mixed character is only likely to increase, especially with respect to the third category of pedestrian. Therefore, there will be no benefit in walking pleasure to or from our property as a result of the waterfront LID improvements. Our property has gone down in value since the announcement of the waterfront LID improvements. It's not worth now what the city said it was in 2020. The King County assessor valuation is higher than the valuation listed on sites like Redfin, for example. The argument that our property value will increase as a result of the LID improvements is patently false. Thank you.
Thank you. Did you have any additional documents there that were not already a part of your objection?
No, I do not.
Thank you. In this category of objectors for today, how many do I have left? Just again, a show of hands. So I've got 3 of you. We're going to press on and get those concluded so that we can take a break after that. If those objectors will come up to the reserved seating. Thank you. We're going to get through these objections. We'll take a short break. I will review the calendar and see where we're at with that for the individuals that were signed up in the hallway, and then have some conversation with some of our larger cases. If you were here and you signed up for the hour or less slot for another day or time, your reward for staying later at this point could be that you come on after the lunch hour. We can give you an earlier time if you want that. So I will offer that to anyone that's still here. If you're if you've taken the day to do this, then we may have some time later in the day, and I will make that available to you. But let's check that when we get there. I'd like to finish with this segment of the objections first, please. Case name and case number and name, please.
My name's Frank Katz, K-A-T-Z. And actually I have two case numbers, one of which you had on the board a minute ago, probably because I was scheduled for 2 at 15 minutes, and listening to how busy you are and knowing how busy I am, I'm going to try and get both of them done in 10 minutes, or pretty close there too. Okay. And the case numbers are 142 and 143. Frank Katz, K-A-T-Z.
Thank you.
So just the background, I live within the Lid District, and my daughter has a separate condominium that lives in the Lid District. The reason I'm here is because today's my 67th birthday, and I have the privilege of having lived in 10 different states and operating factories in 10 other states, and been through a lot of real estate issues. And honestly, I've never protested an assessment of any type before, but this one just really feels wrong to me, and I just want to take a minute and tell you why it feels wrong to me. I happened to be watching David Letterman last night, rerun, so you're going to get my top 10 list. Not a lot of detail here. If you'd like anything more, happy to come back to you. Number 10, and I won't stay on this one long because you already said it's not relevant. I think the process has been really abysmal. It's been incomplete. Even today, when you were saying that we're going to get to talk to the people who did the audit or the valuation after we've already made our objections, it's kind of backwards. We really ought to know what people are thinking. And that's been consistent with the way this is done since the very beginning. Things have not been complete. We weren't furnished a complete list on a timely basis. So that's my first objection. Second objection, which I know you've also heard before, is that this lid, in my opinion, was not really properly created. We have a thing in the United States and in the state which says no taxation without representation. As you're well aware, there's only 6 people. I heard him say earlier the vote was 8-0 in City Council. That's because the one who represents the people in the lid wasn't allowed by council rules to vote. Of the remaining 8 people, only 2 of them have any interest in the citizens who live in this particular district. So it's 6 of the 9 possible votes were kind of by people who have no interest in this, and that's not fair. People need to be able to not just speak, and I appreciate the fact that you're listening, but people have to have an opportunity to vote as well. Third, I know you've heard this before, so actually this is number 8 on my top 10 list. It's not really a special benefit. A special benefit, from everything I've been able to see, you use that for somebody builds a road or somebody builds a utility that goes to a certain area, and you say, you know what, this many people are going to get power, this many people are going to get access. Everything that's in here is just very vague. There's no way of quantifying what this special benefit, the perceived special benefit is. And more importantly, I keep reading all the information. This is a park for all the people. In fact, it's a park for people that don't even live in Seattle. It's a park for the tourists that are coming and come visiting. So I can't understand why people think there's a special benefit conferred on the people that are in the property. I really don't believe there is a special benefit. The value of the lid, I don't know how you measure this. I really don't have the faintest idea how you measure this. It's number 7. Lids were created to fund local improvements and so on and so forth. I just have no understanding of how you're going to measure it. And that goes to the next one, which is that the benefit on this is not really calculated. It's more a question of allocated. They needed to raise some money, so they went out and they said, okay, we got to raise this much money. Let's go find the people that live nearest. And then they said, we're going to get to this $170,000, whatever it is. They come up with a greater formula, and then they allocate it to us. Thank you. 170 million. 170 million. I think, now we get to, my opinion, the more important ones. So I'm up to the top 5 now. The assessment represents a faulty assumption of what provides value to property. One of my condominiums is on the 30th floor of a building, and I have this beautiful view. That's where the value of my condominium comes from. The value is not related to how many people come to the waterfront. I have plenty of access to the waterfront. Oops, I think I'm jumping ahead. That was number 2. We'll stay with where we were. The value of what I do, of what I own, is not related in any way, shape, or form, other than the fact that when you start to build this, you're going to have more and more people there. The restaurants that I go to are going to continue to be overcrowded in the summer. I'm not going to be able to get to them. And of course, there's going to be an increase in crime related to this. So I just don't understand the value assumption. Why is it that I'm getting any better? Why is it that my property will be worth 5 cents more because they're building a waterfront lid? I don't get it. I don't really think there is a value assumption that's underneath this. Number 4, the assessment does not consider what it's going to do to property values as a function of crowds and crime. I mean, we all know that this is a problem area at 3rd and Pike, which is very close to us. Now we're nationally known as the place where people get shot on their way to work and where stores are vacating it. And this is just going to bring more people. The reason that exists is because you have this confluence of transportation and money and tourists, which leads to the drug trade. You're just going to create more. And if anything, it's going to drive the value down. So again, I just don't understand how there will be a creation of any value, which is the basis on which the assessment is being made. Number 3, I'm not going to get any benefit from this lid. I already have plenty of access to the waterfront. I know where the stairs are. I can get down there. I'm certainly not going to be in this park very often. You know, there's no benefit that's given to me in terms of access to the waterfront. Number 2, I have grave concerns about what's going to happen with this park on the waterfront. If you look around the city of Seattle, by and large, the parks that we've built in an attempt to make the city more beautiful have been more of a problem. There is crime. There's an area where the homeless accumulate, and it's unsafe to go through at night. You know, if you live in the area, you know that we walk through the alleys and off to the sides in the parks, that people are urinating. This park, I have grave fears about it. And that leads me to what is really my number 1 objection. This is not, I don't know if this is in your purview, but I gotta say it anyhow. This is not where the city needs to be investing money today. Leave aside the money that they're raising from me. And I know you probably don't look at the bigger picture, but the city, it's got problems. We don't have enough money for our police force. We don't have care for the mentally ill. We don't have the housing, affordable housing for enough people. So as upset I am about the $170 million that's coming through the assessment, I'm almost more upset about the fact that the city is taking, and I probably heard the number and I didn't hear it, probably as much or more, if I had to guess, of their money and their time and your time investing in a project which is not where the city, at least not where the downtown area needs to be spending its money. So that's all. I hope if any of those things are interesting, you'd like any more information, I'll be happy to make sure to get it to you. I'm sure 27 people will protest it for you. But as someone who's lived a lot of places, this is really... Anyhow, here's my top 10 list. Okay. Next time I'll come with a presentation where they show one at a time. So thank you.
Thank you, Mr. Katz. We're going to mark that as Exhibit 1 for case number 142. Just as a quick matter of efficiency, for those of you speaking, there's no need to apologize if someone has said something before. That's normal in public speaking opportunities, but here you're putting on your case, so it's the first time it's heard for that case. So please put on your case.
Our case number is 0216 Doncaster Investments, 3rd and Pike, Melbourne Tower. Doncaster hereby objects to the proposed final assessment for the waterfront lid number 6751 of $324,428.62, which represents the 39.2% of the final assessment benefit of the lit improvements to the Melbourne Tower of $828,000 as determined by the ABS valuation of October 1, 2019, the date of the valuation. Certain data used by the ABS valuation is grossly inaccurate, and we will refute their basis below based on accurate data and information. It should be noted that earlier in 2019, when the values first were posted, that when we were contacted by the city that the value that they were showing for the Melbourne Tower to be $38 million was absolutely incorrect, and asked at that time for the value to be corrected. We were told then that our dispute, to be able to dispute these numbers would be at a time of implementation, which was going to be around October, which is, I guess, now. It shows the gross building area of 138,893 square feet with a net building area of 98,770 square feet. We've been working with the King County Assessor's Office to correct some of this false data. We show our BOMA gross footage to be approximately 113,845 and our BOMA net square footage to be approximately 102,886 square feet. Of that 102,000 square feet, just over 14,000 square feet, or 9,300 net, is our basement and areaway used primarily for storage. Number two, ABS valuation study states that Melbourne Tower market value before the lid improvements $38,346,000, and they've determined a 2.16% positive special benefit. This erroneous value, this $38 million, must have come out of someone's hat. We can't figure it in any way how that's come about. Even King County has determined our value in 2019 to be $23,423,000, which rose in successive years from $22,026,000 in 2018, from $19,331,000 in 2017, and $16,706,000 in 2016. Which is the year that our retailer doubled its space, taking over the second floor, converting the second floor from office to retail. We've contested a couple of these values with the King County Assessor. In fact, we're going before the Board of Tax Appeals here in March. So we don't even agree on the $23 million value. Yes, rental rates have been climbing. So have operating expenses, including utilities, taxes, insurance, labor costs at all levels. Our neighbor, the West Edge Garage, has a similar content of land of 12,582 square feet. It has a similar net square footage of 100,000 square feet. And the ABS report values them at $22,648,000. So they're very close in that value to what King County is showing us for ours right next door. There's talk about, the ABS talks, in extent about what's going to be right for development and the valuation study, et cetera. This may be the case for our neighbor, the West Edge Garage, because they do enjoy the zoning of 240/290/440 classification, which would be an ideal redevelopment, just like the new West Edge condominium tower directly across the street on Pike Street. Yet our zoning at 3rd and Pike does not share any enhanced redevelopment opportunity. It remains under the old DRC 85-170 classification, restricting any kind of redevelopment or potential increase in land value. So even if the county prevails at the State Board of Tax Appeal and their value remains at this $23 million range, similar to what the garage behind us at $22.6 million, then the hearing examiner, we'd ask you that you would reallocate that our cost and our range, that the lit improvement range would be $489,000 to $505,000, that our assessed rate then would be approximately $191,000 to $198,000. In addition, some of the proposed changes that they're talking about for Pike and Pine, and I'm going to specify on Pike, by limiting traffic down to one lane, has caused significant challenges for our street and our building specifically. We used to have 3 lanes. They've already done some of these improvements by adding the bike lane. They've changed it down to 1 lane on Pike Street. There's incredible traffic snarl from 1st to all the way to 4th on Pike Street. We have no access to our building because 3rd Avenue is the transit center. And we have no ability to drop people off or on 3rd Avenue, and now not on Pike Street as well, with only being down to one lane. Our alley can be blocked from a half an hour to up to 2 hours a day with delivery trucks stacked in the alley, especially in the morning hours. Somehow the ABS report says that we're going to see a special positive benefit from all these improvements, and they've decided that we should get a 2.16% a special improvement. And we think that this is absolutely inaccurate and false. We did notice that in other parts of the study, residential assessments got a 0.25% for special benefit. We're going to say that because of these improvements, they're actually detracting from our value. And we think that the special benefit, then, if there is going to be a special benefit, should also be 0.25 and not 2.16%. I think, like it's been said earlier, it should also be duly noted that our location has suffered, and has suffered for years, from negative behavior that exists, specifically at 3rd and specifically on Pike Street. With the air drug use, the open air drug, the dealing, the aggressive forms of panhandling, the theft, the robbery, the assaults that occur, they keep our rental rates lower. Many buildings around town have seen and experienced great, strong rental rates, but at 3rd and Pike, it's a challenge. Real estate brokers often cite that prospective tenants that they might have brought just didn't really care for the area. Safety is always one of those chief concerns and factors. Since the start of the viaduct's demolition, we have seen more homelessness and more mental illness and more of that negative behavior move up into the city, where before it had stayed down below by the waterfront and where the viaduct existed. I attended many of the public hearings as it related to this LID formation and the values that were going to be tried to be added. And one of the things that they addressed was that as a park, they were going to be able to police that better. And one of my concerns being at 3rd and Pike was, well, what's going to happen with all that, all of the negative behavior being moved up into the city? Is that going to be treated as a park as well? And are we going to get the same benefit of the policing and not allowing for the negative behavior of homelessness and mental illness and open air drugs being perpetuated on our sidewalks and our alleys? The defecation, the urination, and some of the other things that have already been mentioned. Until the city really addresses and takes firm corrective stands against all that kind of negative behavior, we're not going to see rent increases and values increase significantly like the rest of the city might have experienced. This is totally independent whether lid improvements are made or not. The lid's not going to add $1 of value to our property, and so we don't believe that the assessment at all is a benefit to us. We asked the lid examiner here that we would ask you that you would consider a value of $19,300,000 before the lid assessment. We'd also said that you would accept less than a 2.16% positive special assessment to be taken into account based on our neighborhood and the limitation that we have for any kind of land value increase, et cetera. We would ask you consider a 1.08% based on the value of $19,300,000. Which at 39% would take us to a special assessment of $208,000, which would take our assessment down to $81,708.48. I did provide this in writing already, but I wanted to be able to share that orally as well. Thank you.
Thank you. And just, I want to make sure we're clear on the record. I got your case number 216, and you indicated you were speaking for Doncaster Investments, but I didn't get your name.
Lou Bond.
Thank you.
L-O-U-B-O-N-D.
Thank you.
Thanks a lot.
Next. Case number and name, please.
Good morning. It's case number 0352. My name is Bill Pitlick. I live at Marketplace North at 1st and Virginia.
And could I ask you to spell your last name, please?
Pitlick, P-I-T-L-I-C-K.
Thank you.
I'm here to contrary to what you've asked, I'm here to say that I think the lid is totally inappropriate, arbitrary, and capricious. It's improvements that will be appreciated on a national scale. International scale, we have tourists most of the people that within the lid will not be using it. So it's not of special benefit, and I'll talk more about that later. But the calculation of my lid assessment is totally arbitrary, and if my and it's I don't know how they calculate it because there's no time frame associated with it. Is this the increase in assessment over increase in value over 5 years, 10 years, 3 years, 1 week? I don't know what that assessment is, but that will have a huge effect on the actual valuation, increase in valuation of my property. If you're talking about 10 years from now, when my payment will be done with the lid, if I pay it, you know, that's an increase in that's a insignificant amount. If it's this week, that increase in valuation is quite significant. But I will say this, that the valuation that they've proposed, regardless of when it is within the margin of error, as noted in the Gibbons letter, which I've attached to my objection. It can't be discerned. It's the difference between a head of lettuce costing $1 and $1.02. And you're going to tell me that 2 cents is because it rained last week in the Central Valley in California? There's so many factors that go into that increase in valuation that you can't set it on one specific variable, such as the lid improvements. Now, I'd like to talk about the lid itself. There's 6 different projects in the lid. First of all, there's the Promenade Park. There's Pike and Pine Street improvements. There's Pioneer Square improvements, Pier 58, and the Overlook Walk, sorry. First of all, the Promenade Park is, as Mr. Jacobs said earlier this morning and others have said, this is not really a park. This is a commercial roadway. We're going to plant some trees alongside it and call it a park. I have significant problems with the fact, as the previous speaker noted, that the city does not currently is unable to police the parks that we have. How are they going to police this brand new park? They're going to take resources away from the central core, put them down in the Promenade Park. And I particularly point to Victor Steinbrook Park, which my condo is within 100 feet of. It borders on Victor Steinbrook Park. That park is well recognized as a home for derelicts. There's public urination, defecation, drug dealing, open air drug dealing, and the city can or won't control it, despite police presence there and 911 calls on a daily basis. It goes on. So there's no guarantee that this, and Victor Steinbrook Park adds zero benefit to my property value. The fact that it's a beautiful park right there, you can't use it if you're an owner of our property. And I think the same thing will apply to the Promenade Walk. The city won't be able to police that adequately, and it will turn into an area for homeless people and have the same problems as other parks around the city. Now, one other project within the lid assessment is street improvements around Pioneer Square. Pioneer Square has no relationship to where we live in the Pike Place Market. We never go to Pioneer Square. I'm sorry, but most of the people in our condo probably don't go to Pioneer Square, maybe once a year or something. So it's of no special benefit to us to have improvements in Pioneer Square. The other street improvements that they talk about are the improvements on the Pike Pine corridor between 2nd and 9th Avenue. Now, 9th Avenue is not even within the lid. So why aren't the people on Capitol Hill part of the lid? They're the ones that are going to benefit from street improvements on Pike and Pine. And as the previous speaker noted, the street improvements they're going to do, they're going to make it a pedestrian boulevard and blah, blah, blah. It's just going to increase traffic congestion more and more downtown, make it more and more difficult. That's not going to increase property value, and it's certainly not going to increase my benefit. The special assessment report, the ABS report, Valbridge report, talks about how these improvements are all going to improve access between the central core and the waterfront. There are currently at least 5 stairways and 3 elevators that go from Western Avenue or the market down to the waterfront. I have plenty of access. As people before me have noted, there's plenty of access to the market. We don't need more access. And That brings me to the last point, and that is this Overlook Park. The original design for the western market front was to have a gradual walkway that went back and forth, switchbacks down to the waterfront. That changed because the aquarium now wants to build an addition across the street from where they currently are. And that will be this huge concrete monolith, 28 feet high above the roadway. So there'll be a walkway then with steep stairs down to the waterfront, which is going to be inaccessible to ADA folks. So that is not a special benefit to me. In fact, that's going to be, to me, a real eyesore because it will take away from the view. You'll stand up on the beautiful new western part of the market, look out over the water, and what will you see? You'll see the big concrete block out in front of you. I don't think that's an improvement at all, and that's not going to add to my special benefit. So I think the whole LID process in general is specious. I think the city realized this is a chance to soak the condo owners and businesses downtown and put all these projects that they want to fund that they haven't been able to fund previously into a package and tax us for it. I think it's arbitrary and capricious, and I object to it. Thank you.
Thank you, Mr. Pitlet. All right, we've completed the 5 to 10 minute objectors. We're going to take we will take a break in just a moment. Before we get to the break, are there any objectors here today that are within the 5 to 10 minute range that have not spoken yet? So I've got one individual. You'll get a chance, sir. We're not going to, you just walked in. We're not all going to stop and wait for that. You'll get a chance right after the break. So I've got one objector who will come after the break. Are there any objectors here who got allocated a time for greater than 5 to 10 minutes, but less than an hour remaining here that would like to go later this afternoon? All right, please wait for after the break, and it looks like we will have time to do that so we can get you done today as well. And it looks like there's a couple, or at least one or two of you. And at that time, we'll also work out our calendar to the degree we can with our larger cases. We will take a break until 11:15 and return at that time. Thank you. And we return to the record. I have one request for an objection to be presented today, and that is case number 254. Not seeing the individual still here. If case number 254 comes back, I'll give him a chance to do his oral presentation. Moving on from that, then let's look to calendaring for the items that we had left, and that was Mr. Lutz and Mr. Williger. Mr. Williger, you've requested 3 days. That's exceeding what other attorneys are doing for the same number of clients. However, it's likely that you'll file somewhere, maybe 2 days or what have you, and we can look for efficiencies when we get started. So right now I'm going to calendar you for 3 days, but expect at the beginning of the hearing we can look for ways to overlap and make sure that you're not doubling up on presentation, et cetera. Again, I've got other attorneys that are looking at about a couple hours each client. So if you've got 5, that's quite a bit of time. So. Yes. But for now, I'll leave you with 3 days, and that's going to put you on February 24,
Okay.
25, and 26.
February.
Yes.
Yeah, I'm unavailable the 25th. We could do.
And I'm sorry, I can't accommodate schedules for this. I understand. Typically, we always try to do that the way we can, but this is exceptional for trying to calendar, and we can't change the calendar. All right. So you have your dates?
24, 25, 26?
Yes.
Okay.
Okay. Then the other request was from Mr. Lutz. For now, I can assign you, well, just as general information for all council, anybody who cares at this point. As you can see, we're entering the end of February for the number of objections just to address this hearing. I'm going to give Mr. Lutz 4 dates that I have available in the very beginning of March. The extra challenge that we have are, for those who are familiar with our processes, 8 MUP appeals, which I don't think I've seen filed all at one time, have been filed, and we need to get them in the hearing process as well. They will take up a number of dates in March. Therefore, my expectation is that we are going to be getting city presentation as late as April on this. And so, as late as April. Can you hear me, Cal? Okay. All right, all right. You're welcome to approach the bench too, if the mic, if you like, for scheduling purposes. Now we're essentially down to scheduling Mr. Lutz in the city.
And actually, before you start with me, I'm introducing Mr. Charette, who is also the appraiser for another lawyer who's in Spokane, who I think already has a date, but there's a scheduling specific issue he'd been asked to address.
Yes, hi, Peter Charette, and Todd Roeder is an attorney with Foster Garvey. And
right now he has, I can tell you his dates.
I've got those dates.
18, 19, and 20 for his 10 clients.
He also has another one that he filed yesterday. It's the Hilton Hotel property, and he's requesting a time period for that, to hear that as well.
Okay. For now, I'm going to ask him to put his cases on the 18th, 19th, and 20th.
I'm not a lawyer, so I can't respond to that.
I understand.
I didn't know that. Thank you.
He'll understand that.
Yeah,
he's not getting all the time he's asking for, basically. But he's given 3 days for his clients. So continuations will be addressed at the time of those hearings.
I just wanted to clarify, my colleague reminded me that the appraiser for the city has some unavailability between now, the 24th, 25th, and 26th, and we need to take that deposition before the 24th. So if he can be available this week and next week for deposition, that would work, but I was reminded that he has some unavailability between now and then.
Anything from the city on availability of your witness for a deposition?
Yeah, and this is actually one of the issues we wanted to discuss in terms of scheduling. So discovery was news to us to some extent, to the extent that there will be depositions allowed. Obviously, the objectors have had several months with Mr. McCauley's report. To the extent that they are intending to present expert testimony or appraisers, we would want likely the opportunity to depose them as well. Doesn't directly address your question, but it's one of the things I wanted to put into the mix as we talk about scheduling.
Certainly.
And then in terms of Mr. McCauley's schedule, certainly we can check in the next couple of weeks, but we had not anticipated having him, again, because we weren't anticipating depositions, having him go before the end of the objector's testimony. So I'm not prepared right now to answer that specific question.
Understood. All I can ask then is that the city make an effort to have him, his schedule, so that he's available for deposition prior to the scheduled hearing dates. We're trying to accommodate his vacation schedule as well, so if he can make the effort to get these done so that we can stick with the schedule for Ms. Terwilliger's case schedule, that would be appreciated. If it's wholly unaccommodatable, we'll need to get you new dates because you would have the ability to depose before. And then any other issues as far as depositions, interrogatories, et cetera, I don't expect to be a part of that process unless I hear from either the city or any party that there's an issue between us and we need you to settle it. Otherwise, I would just expect you to go ahead and schedule any depositions between yourselves. I'm not setting any type of discovery schedule unless asked to at this point.
Thank you.
And Mr. Examiner, I just wanted to clarify your initial proposal for our 29 clients was 4 days?
Right now, I can identify 4 clear days on the calendar for you.
Okay.
Yes.
And then if
at
we
that
need more
time-
time than that, we'll ask for additional time.
We may even work that out before then. Right now, it is February, the very beginning of February. We're talking about a hearing that's now starting in March. And I wasn't, coming into this, I didn't know if we would need March dates for the hearing. So at the beginning of the hearing on the fly, I found you 4 dates. And if there are more in March, we'll be able to identify those soon, or if we need to go into April.
Okay.
Which I expect is a reasonable possibility. At this point, I don't see how we could, if you need more time and the city's going to need time, does the city have an estimate on how much time it may need for its case?
I would imagine that we would need 2 days at least.
And that's not even accounting the cross-examination that I assume is going to take a day or two, given that. So we need 4 days for the city, possibly more days for Mr. Lutz. We're not going to come up with that many days in March at this point. Because we need to stop and get some of our MUP hearings addressed.
And my only comment was my initial rough estimate is 7.5 days. So half a day per.
Okay, well that's better than a full day each, which was implied in your motion. But
half day each.
Okay, that's helpful, and we'll see what we can do with the 4 days. But we may go ahead and try to find. What I'll try to do is find 3.5 days more for your caseload. Year 29, was that right? Cases.
Yes.
And then the city, so that we can have some prediction for the parties as to when the city will be putting on its case and that they'll be able to cross-examine. And I'm expecting at this point that those are going to be April dates. I want to make sure I'm talking. I know you've got questions, but I want to make sure I'm hearing from the city. Does this work for your case schedule?
It should. So if I'm tracking correctly, we would have approximately 2 days to put on our direct testimony, and then I couldn't hear the number of cross-examination days that you had.
I'm going to set aside 2 more days for that, just based on what I'm hearing from the need and the number of objectors, whether we'll actually use that or not. As you can tell on this side of the dais, part of the problem with me is making sure we have the time set aside. I'd rather set aside the time for you to make sure we have it and we don't wind up in June.
Right.
Even if we don't use all of that time, it's not an invitation to take 2 days. It's just making sure we have 2 days to address.
And similar on that point, just circling back to the deposition issue, you may hear from us in writing if you prefer. Our proposal, sketching this out during the break, would be along the lines of having Mr. McCauley available for deposition for everybody who wanted to ask him questions. Our concern is that between now and when we put on our case in chief, we could easily be in serial depositions with Mr. McCauley. And of course, we would want to likely depose any experts or appraisers that parties may be calling. So I think we're going to need some help to work through that scheduling process to make sure it's fair.
Okay. If you do, that's fine. Please contact me for that. But one thing, if you could remain at the mic for a second, I'd like is if you can accommodate, since Mr. Williger has a case date, has already identified, we have a specific request on the table, essentially, for that deposition. If that can be accommodated prior to the appraiser's schedule for holiday, that would be welcome so that we can keep the case schedule we have now. And if I can finish. If you get other deposition requests and you need to consolidate those into a single time or maybe after the vacation time or something along those lines, then that's going to be acceptable. So I'm trying to give you some guidance now with regard to that scheduling, if I can.
Okay, well, I appreciate that. And one of the questions is, if we are going to put Mr. McCauley on before his vacation later this actually, I'm not sure if it's a work trip or vacation, but I know he's leaving the country.
We're making assumptions. Let's
No,
before his
absolutely.
absence.
We would, and we can work with Mr. Williger on this, but we would want, again, if they're going to have an expert report, we'd want to have that prior to the deposition.
Okay.
Just one more clarifying point, and I guess 2 questions for the examiner. Part of our trying to schedule our hearing time, I am anticipating that we could proceed with appraisers giving reports rather than, with limited questioning so that it could be more efficient rather than having question answer. But we will defer, obviously, to your preferences.
You're asking for efficiency's sake if during your presentations, if an appraiser or an expert witness can essentially make a statement rather than question answer, yes.
Correct.
And I'll look to that to any party. If you can find efficiencies in how you're presenting, please proceed with that. This is an unusual hearing. I'm most interested in getting the evidence in that you want to present and not looking to a specific format for that to come in.
And the follow-on to that was back to this original idea we have about the question of the environmental review of Pier 58. That's really one question that is raised in each of the appeals and relevant to each of the appeals. But I think in terms of you hearing it, it can be one presentation with one set of witnesses, if that seems efficient. If you prefer that we do it in each case, that's fine.
No, I think any of you that have multiple cases, if you have either subject matter issues that you want to address or specific legal issues you want to argue for those cases, you can do those at a single time rather than having to do it repeatedly for however many cases you've got.
All right, thank you very much.
Not going to be efficient for anybody.
Thank you.
Just one last point on the deposition front. Again, our position, and I didn't go through my legal standards piece this morning. I'll reserve that for later. But given the standard here, the standard of review that should be applied, objectors are required to come forward with expert testimony or at least rely on some in the record in order to overcome the presumptions. That ties into our concern about the depositions. If folks are seeking to depose Mr. McCauley or others, simply to ask them cross-examination questions without the intent to call an expert, we believe that the correct forum for that would be here, in open hearing. To the extent that they do want to depose him beforehand, again, we would want to know that they were retaining an expert and have a chance to review that report beforehand. And not the day of the deposition, I suppose. Understand you want me to work these out with counsel. That's fine, we'll do that, but just wanted to get it on the record what our position was.
I think it's fair to use this forum to do that. We're trying to organize it as much as possible, so I understand the city is explaining its position with regard to depositions. It's certainly a position I would support if I have a motion coming in front of me, that we're not just having an opportunity to depose the city for the sake of deposing. If you're not putting on a case, I don't necessarily need you to try to put it on through the city. I expect you to be putting on your own case, and I know that some of you are, and if you're going to do that, then the regular avenues of opportunity for deposition will be provided. I'll look to anything further on that, just reserve it for motion practice if necessary. Mr. Lutz, your 4 dates are March 3rd, 5th, 11th, and 12th, and I assume somebody else is writing these down for you.
Yep. Thank you.
All right. I will seek to identify dates in April to finish out your request for another 3.5 dates, and I will also look for 4 days in April that will identify the schedule for the city. Did I have the speaker for case number 254 return? All right. Hearing none, we'll move on beyond that. Are there any other cases for anyone that has not yet had your case scheduled that I need to address as part of our hearing today? With that, I think we can adjourn for the day.
Less than an hour speeches?
So we've done all that. Oh, I'm sorry, you're right. Thank you for reminding me. I apologize. Yes, we had a third category, and that is individuals who were scheduled. And I think we had 1 or 2. Is it just you're just the one? All right. Why don't you come up to the mic? And this is going to be the last thing that I do today. So if anybody doesn't want to stay around, you're welcome to leave or stay either for this presentation. May I ask your case number?
0054.
And what is your name? Mm-hmm.
Is Madeline Brindle.
And how long was your estimated time when you indicated?
I can probably read this in about 25 or 30 minutes.
Okay, thank you.
And I will read it for the sake of efficiency and for not forgetting anything.
I understand.
And I have two documents here. I did submit them when I mailed in my So I don't know if you want another
Came
copy.
in with your objection. We don't need another copy. I have your objection, but if you have any new
No,
document, okay.
they were
all right.
sent in with my
All right,
written
then,
objection.
please proceed.
I object to my assessment for the waterfront lid because I question the very legitimacy of a local improvement district as a vehicle for financing the waterfront park. First point, the nature of a local improvement district. The waterfront local improvement district at best represents a questionable interpretation of the intent of the statute governing the use of an LID, and it is an inappropriate application of the LID process. A local improvement district typically funds some specific improvement or infrastructure, usually related to safety or public health, added to specific properties. Examples would be the addition of curbs and sidewalks, paved roads, street lighting, or city water and sewer lines. The improvements might be deemed too specific or too local to warrant funding with public monies. Hence, the owners of the specific properties that would enjoy measurable special benefit from the improvement would be asked to pay for them, and a local improvement district would be formed to fund the project. A typical lid may encompass a few hundred parcels. There are 6,211 parcels listed on the proposed final assessment roll for the waterfront lid. An LID would typically originate with a group of property owners wishing to add infrastructure improvements, such as those mentioned previously, to their properties. One of the first steps would be a survey sent by mail to the property owners who would be assessed to determine the rate of approval of the desired improvements among those who would be paying for them. There has never been such a survey connected with the waterfront lid. Instead, in early 2018, only after plans were well underway for the park and the project had already been splashed across the pages of the Seattle Times, were we informed that, by the way, we would be funding approximately 25% of the project with lid assessments. There were public comment sessions held at City Hall on 3 separate occasions where we could express our views. I might add here that no more than 2 members of the City Council ever bothered to attend these forums until the meeting at which they voted to form the lid. Of the dozens of speakers at these open sessions, only one person, other than members of the Waterfront Park Committee, spoke in favor of the lid. She was a woman representing SAM, the art museum, an obvious beneficiary of tourism and likely exempt from assessment as a nonprofit. Any reasonable person listening to these sessions would assume that the idea to form a lid to fund a waterfront park was not being well received by property owners within the lid area. Subsequently, in July of 2018, after the motion was passed to form the lid, a series of public hearings were held before a city hearing examiner. We understand that over 300 comments were presented, but we have not been privy to the results of those hearings, as the City Council is claiming immunity due to the quasi-judicial nature of this issue. Nevertheless, it is difficult to imagine a sudden about-face of the respondents suddenly favoring the lid. It is patently obvious that this and former city councils have been lobbied long and hard by the Waterfront Park Committee for years, and the Waterfront Park was a done deal, signed, sealed, and delivered behind closed doors before it was ever presented to the Seattle citizens in general, and specifically to those in the designated local improvement district who would be expected to pay a large portion of the bill. As previously stated, downtown property owners were informed in early 2018 that we would be funding approximately 25% of the Waterfront Park project with the formation of a local improvement district. Barely more than 11 years earlier, in the fall of 2006, Seattle voters defeated, for the second time in as many elections, the proposed Seattle Commons project. On at least 2 occasions during aforementioned public comment sessions at City Hall prior to the formation of the lid, a member of the Waterfront Park Commission made the point that they had been working on the project for more than a decade. I find this timing more than a coincidence. The waterfront lid was selected as a vehicle for partial funding of the waterfront park after it became obvious that Seattle voters were not going to support such a project. The waterfront lid is a vaguely defined group of enhancements to be added to an already existing major waterfront improvement project, including the removal of the viaduct, the rebuilding of the seawall, and the construction of the roadway and the promenade, which enhancements are intended to create a major attraction for visitors and tourists to the waterfront and to provide easy access for those tourists to the Pike Place Market and Central Downtown Business District, coincidentally including the newly expanded Convention Center. This is a park located in a regional economic center and intended to benefit the region and beyond, and many of the properties allegedly deriving a special benefit from its presence are located several blocks away and on an entirely different elevation than the waterfront park. My second point deals with the Val Bridge appraisal method for assessing the special benefit. The assignment of waterfront lid properties and the presumed special benefits thereto, as presented in the Val Bridge study, has been completely arbitrary. For one thing, the lid boundaries have been amended at least once, demonstrating once again the arbitrary nature of the assignment of special benefits. At this point, I will refer you to the letter from Anthony Gibbons of Gibbons and Riley, which I have previously submitted. They are real estate appraisers who also provide counseling and mediation on the subject. They were asked to conduct a high-level review of the Valbridge Mass Appraisal Study, prepared for documenting special assessments attributable to the Waterfront Seattle project. Mr. Gibbons states therein, quote, "A successful lid is based on a correct identification of the special benefit created. The most succinct definition of a special benefit is provided as a WPI instruction. I must confess I could not determine what WPI stood for. I assume it's some professional designation for an appraiser. The quote, "Special benefits are those that add value to the remaining property as distinguished from those arising incidentally and enjoyed by the public generally." Further, quote, "The value lift associated with provision of the infrastructure, say water, power, or sewer, is typically easily measured, and special benefits are not hard to prove and calculate." End quote. A further quote, "The special benefit associated with an amenity such as a publicly owned park is not obviously beneficial in the same fashion as a utility extension, representing more of an aesthetic and widely dependent upon factors unrelated to the mere presence of the project, such as operations, public use, etc." And I will comment on that at a later point here. Mr. Gibbons goes on to state the importance of identifying special benefits as opposed to general benefits, those that are enjoyed by the public generally. And if a project creates both special and general benefits, only the special benefit that accrues to certain properties can be included in the assessment. And special benefits cannot be, quote, "remote, speculative, or imaginary," end quote. This once again from the WPI, that elusive organization. The Valbridge study makes no distinction between general and special benefits, so it is apparent that the special benefit study includes both types of benefits. To this, Mr. Gibbons writes, quote, "Beyond the lack of recognition of general benefits, it is noted that the very nature of the public improvement, a regional park, and the wide lid boundaries described in the report suggests that entire project could be described as offering almost entirely general benefit. Almost by definition, if $48.1 billion of real estate is impacted by the project, the benefits provided would seem very general and widespread in nature. Furthermore, the method used, applying arbitrary percentages to an arbitrarily determined before value to determine a special benefit, represents an improper method for a special benefit study. It is considered a shortcut, typically used for small projects such as creating a small easement. The special benefit should be calculated based on the value of the property without the benefit and the value with the benefit. The Valbridge study selects a collection of arbitrary percentages of special benefit and applies them to some seemingly also arbitrary before values. Additionally, the Valbridge special benefit assignment is based on a proximity benefit. Proximity is a characteristic of the land, and benefits from proximity do not accrue to improvement value as the physical location has not changed. Thus, vacant land that will imminently be developed but has its special benefit assigned based on the value of the vacant land in 2018 will create an inequity when applying the same percentage to side-by-side properties already improved in 2018. The special benefit needs to be calculated by measuring the actual before and after differences. I would like to include here Mr. Gibbons' concluding paragraph in his review of the Valbridge Mass Appraisal Study for the waterfront lid. And I quote, "The more general issue is the difficulty of trying to forecast a benefit that is special to a park that has regional appeal. The more common application of an LID is for extension of infrastructure. And here special benefits can be practically and incrementally assessed to unserved property brought to a development condition through the provision of infrastructure. However, the application of the special benefit methodology to a downtown area for a park amenity represents a challenge and potential impossible assignment if it is to be free of speculation and imagination." And additional comments on the assigning of special benefits and assessments to property. Many factors could cause the properties within the lid area to fluctuate 1/2 to 4%, which is the percentage they use, at any given time. It would be necessary to demonstrate that any increases were essentially isolated within the lid area to prove any relationship to a special benefit. And it is entirely possible that the waterfront park could have a detrimental effect on our property values. First, there is the as yet to be determined construction period, which will have a definite impact with noise, dust, and general inconvenience related to street closures, sidewalk closures, etc. And the closer the property is to the project, the greater will be the aggravation and disruption during construction. But additionally, the very nature of the waterfront park itself could have a negative effect. In his paper entitled "The Impact of Parks and Open Spaces on Property Values," John L. Compton of the Department of Recreation, Park, and Tourism Sciences at Texas A&M University writes, quote, "Large, flat, open spaces, which are used primarily for athletic activities and large social gatherings," and here I might editorialize about the open concerts that take place and are proposed to be in many more numbers down on the waterfront. Such a park are much less preferred than natural areas containing woods, hills, ponds, or marsh. Further, it must be recognized that there are contexts in which parks exert a negative image on property values. He continues, "Adverse impacts may result from nuisances such as congestion, parking, litter, and vandalism, which may accompany an influx of people coming in a neighborhood to use a park. Noise and ball field lights, or stage lights from the concert, I might add, which will intrude into adjacent residences, and poorly maintained or blighted derelict facilities or undesirable groups congregating in a park engaging in morally offensive activities." End quote. While the Waterfront Committee has committed to ongoing dedicated funds to ensure proper maintenance and adequate security in the park, the source of those funds is to be philanthropy. Philanthropy is not a reliable source of funds. It comes and it goes, and it requires constant nurturing, more at some times than at others, to maintain a needed flow of funds. But the needs for maintenance and security in a large park will be constant and persistent. Victor Steinbrook Park consists of barely a square city block, and yet the city has been unable or possibly unwilling to stop the tents from sprouting there this winter, and it is regularly the site of some crisis or another requiring the visit of emergency vehicles, police or medical aid or both, often 3 or 4 vehicles at a time. The challenges of the many acres of the waterfront park will be tantamount to Victor Steinbrook Park on steroids. In short, there is a distinct possibility that the waterfront park will have a real adverse impact on our quiet enjoyment of our homes, which is, in fact, a statutory right. Point number 3, recouping the money paid by property owners for the lid assessment. If, as the Waterfront Park Committee and the City Council project, the Waterfront Park brings an influx of tourists into the waterfront and downtown areas, many commercial properties will have a means to recoup the cost of their assessments. Restaurants, hotels, and many retail establishments will benefit from more foot traffic. And of course, there is the obvious solution of raising prices. Apartments and owners of other residential rental properties and commercial property owners can raise rents on their tenants. Residential owners who occupy their property will have no means to recoup the cost of their assessments, save the sale of their property. And then, only if the arbitrarily assigned special benefit does in fact materialize, will they recoup anything. Of course, as is always the case, should the property value increase for whatever reason, those owners who remain in their homes will be faced with the added burden of increased property taxes. But that is good news for the city, as even if those increases bear no relation whatever to the presence or absence of a park on the waterfront, the benefit of those increased taxes will accrue to the city for many more years than the 18 years set out for the collection of local improvement district assessments. Item number 4. Requirements for assessing properties and forming a local improvement district. First of all, no specific plan exists for what enhancements are to be paid for specifically by the LID. The Waterfront Seattle website only indicates $8 million for LID administration. By law, once the city has produced a final assessment roll and commenced collecting assessments, they are obligated to complete the LID improvements exactly as laid out in the plan presented at that time, regardless of the cost. Theoretically, when an LID is formed, specified private property owners pay an assessment for specific improvements that will provide measurable special benefit to their designated properties, and they are entitled to receive exactly what has been promised at the price they have paid for it within a reasonable period of time. In a letter from the city dated June 8, 2018, the subject of which letter is Notice of Adoption of Resolution of Intention to Form and Notice of Public Hearing on Formation of LID. It is stated under Section 1, Declaration of Intent, that, quote, the improvements shall be in accordance with the plans and specifications prepared by the Seattle Office of the Waterfront and Civic Projects, OWCP, as a division of the Seattle Department of Transportation, and may be modified by the city as long as modification does not affect the purpose of the LID improvements after the formation of the LID, end quote. I beg to differ. Any such modifications would be illegal and surely be the subject of litigation. And then it is important to note that the Office of the Waterfront is a division of the Seattle Department of Transportation, and the Waterfront Improvement Project is under the supervision of the Department of Transportation. Added to their already existing track record for planning, budget, and timeline debacles is the recent news that the department is under possible criminal investigation by the U.S. Department of Transportation for questionable use of federal grant money. Among the 6 major projects for which records were subpoenaed are final design of the Elliott Bay seawall and design services for the Central Waterfront. Returning to the subject of completion of the LID improvements exactly as specified in the plans on file and collection of assessments is begun, regardless of the cost. Even if current costs and budgets, which are likely years out of date, are brought current, cost overruns are more than a possibility. And given that the Seattle Department of Transportation is supervising the project, I would say they are inevitable. That scenario could eventually bankrupt the city, either with the necessity of future city councils to produce a set of waterfront improvements that this city council obliged the city to complete with 2020 or 21's LID formation, or alternately with endless litigation to try and extricate itself from the obligation. And it goes without saying that this city has far greater needs than a major tourist attraction on the waterfront. How impressed will visitors be after they have traversed miles of trash and homeless encampments in gridlock traffic, or maybe even been shot at getting off the bus, going to visit our gleaming waterfront? Even Sally Bagshaw, in her comments quoted in Crosscut on July 6, 2018, having proceeded to sing of the glories of the proposed waterfront park, said, quote, "If we were just sitting down today and trying to decide, are we going to do something like this today, I think you and I would say no. But we've been working on this for 15 years. If we don't do it now, it'll be another generation before we come back to it, and that would be a shame." End quote. An even bigger shame would be saddling future city councils with the prospect of bankrupting an already beleaguered city for the sake of completing such a project. But in the event the City Council insists on going forward with the project, first and foremost, a specific plan must be presented detailing exactly what improvements are to be funded by the local improvement district. What specific amenities or infrastructure that give measurable special benefits to our specific properties, more often than not several blocks away from the site of the park, are to be paid for with our assessments. It is also essential that we be presented with start dates and completion dates before anyone attempt to assign any special benefit to our properties. And last, the taking of property without recourse. Finally, I wish to address the question of the taking of property leaving no recourse, otherwise known as taxation without representation, which is in fact unconstitutional. Our present City Council is comprised of 7 members who each represent specific districts and 2 members at large. That means of the 9 members, those of us residing in the Lid area are only represented by 3. Andrew Lewis, our District 7 representative, and the 2 members at large, Teresa Mosqueda and Lorena Gonzalez, making them the only 3 members of the City Council that we have any control over voting into or out of office. The other 6, in fact a supermajority, in no way represent us and are in no way beholden to us for whether or not they get in or stay in office. Yet the council was able to vote, and they did so unanimously with the exception of our then District 7 representative, who was asked to recuse herself, to form a lid, thereby assessing a lid tax on the properties belonging to a group of citizens, whom 6 of them did not represent, and there being no consequences for the constituents represented by those 6, as all lid properties were located within District 7. There is therefore no recourse for those of us taxed by the lid, as a supermajority of the City Council is beyond our reach politically. It would be as if the legislature in Olympia wanted to build a new highway across the state, and being in need of additional funding, they voted unanimously to assess the citizens of Ellensburg with a tax to make up the shortfall, having made an arbitrary decision that Ellensburg was the city closest to the highway and would therefore enjoy a special benefit. Of the 98 representatives in the Washington State Legislature, only a handful represent the residents of Ellensburg and are dependent on the voters of Ellensburg for their jobs in the legislature. The people of Ellensburg would have no recourse because the vast majority of state legislators are beyond their political reach, and the constituents of those legislators are unaffected by, perhaps even unaware of, the tax. You may argue that it often happens that a governing body passes a law affecting all of its constituents that some argue is less favorable or even unfair to them. But in those cases, the law that was passed by the whole body applies to everyone in every constituency, unlike a tax assessed by the entire legislative body on just a small percentage of property owners in just one of the constituencies, which property owners are not represented by most of the legislators in the body and do not vote for them. And the rest of the constituencies are unaffected and possibly even unaware of this tax. Then you may say that we did have recourse, that all we had to do was secure an objection to the lid from property owners representing 60% of the value of the lid properties. In fact, only about 12% of the value of the properties in the lid was in the residential properties, with the remaining 87+% being in commercial properties, many of whom would stand to gain from additional tourist trade, and others who had remedies in the form of raised rents to recover the cost of their assessments. In addition, the fact that there were nearly 6,200 parcels represented, merely determining ownership, much less contacting them in the limited time allowed, presented a major challenge. In summary, 1, the Seattle waterfront lid is a disingenuous usurping of the lid process by the Seattle City Council to fund a pet project sold to them behind closed doors by the Waterfront Park Committee and should not be allowed to stand. The assignment of number 2, the assignment of lid properties and special benefits thereto is totally arbitrary. The Seattle Waterfront Park provides no special benefit to my residential property, and in fact is likely to have an adverse impact on my quiet enjoyment of my home, to which I am entitled by law, thereby negatively affecting my property value. Number 3, a residential property owner has no remedy for recouping the money paid for a lid assessment short of selling his property, and then only if the property has actually gained the special benefit arbitrarily assigned to it by the Valbridge study. Number 4, before initiating collection of lid assessments, the city must produce a specific plan for the lid improvements, detailing exactly what features of the waterfront park are to be funded by the lid, and it needs to produce a realistic timeline for beginning and completion of the project. In addition, the City Council needs to understand that by moving forward with the lid, it will stand to bankrupt the city down the road as future City Councils attempt to comply with the legal obligation to complete the lid improvements exactly as specified. Number 5, the lid assessment is an unconstitutional taking of property equating to taxation without representation, leaving me and other property owners within the lid area without recourse. That's it.
Thank you, Ms. Brindle. I believe that concludes our objectors who are intending to speak today. Is that correct? All right. With that, then, I thank all of the objectors who have presented today, also council who have cooperated in working through scheduling and other matters. All exhibits presented today are admitted. We will adjourn and continue the hearing to reconvene on Wednesday, February 5th at 9:30 a.m. at the Office of Hearing Examiner, 700 Fifth Avenue, Suite 4000.